I'm just going to stop my video and step away for a bit.
Okay, you can go.
Okay. Ublakut, everybody. Tumusavitsi, good morning and welcome. I'm Sean Maley, the chair of the Nunavut Assessment Appeal Tribunal and the chair of the panel appointed to hear these appeals. I'm participating today from Yellowknife. But before we start, I'd like to give some brief introductory remarks. The Nunavut Assessment Appeal Tribunal is sitting to hear appeals filed by Kikitani Inuit Association and Baffinland Iron Mines Corporation relating to the Government of Nunavut's action pursuant to the Property Assessment and Taxation Act in respect of the Marys River Mine. The appeals involve 4 consecutive years with the initial disputed assessment in 2014. These appeals reached the Nunavut Assessment Appeal Tribunal from a different tribunal called the Board of Revision. The assessment of value, complaints, Board of Revision decisions, revised assessments of value, and notices of appeal to this tribunal are all in the tribunal record. The panel will sit from 10:30 to 4:30 p.m. Eastern each day this week, April 19th to the 23rd. We will take a 1-hour lunch break at 1:30 p.m. Eastern each day. We may take a shorter
Mr. Chair, you're on mute.
How long have I been on mute?
Only briefly. After you said we may take, just after you.
Okay. Okay,
yeah.
thank you. Sorry about that. So we may take a shorter mid-morning and mid-afternoon break at times which are convenient to all of us during the week. The parties before the tribunal today are the Kikitani Inuit Association and Baffinland Iron Mines Corporation. The respondent is the Government of Nunavut. The panel has convened this hearing using digital media because of the COVID pandemic restrictions across Canada. To provide public access to these hearings, the Nunavut Assessment Appeal Tribunal has arranged for an audio-visual webcast on YouTube. We have also arranged for an audio podcast in case internet bandwidth restrictions may be a limiting factor for audio-visual webcasts in Nunavut. The internet addresses where the YouTube or podcast can be located are contained in a public notice published by the tribunal in the paper and digital editions of the Nunatsiaq News last week and the digital edition of the Nunatsiaq News this week. I would like to introduce each member of the panel. I will then introduce the panel secretary, and then I will introduce the panel counsel. I'd like to begin with Paula Madden, Rick Armstrong, and myself, of course. And our secretary is Olivia Forbes-Bullion from Kuluktuk. And our counsel is Kirk Lambrecht and Fahim Rahman from Alberta. Our secretary is available to display documents in the tribunal record should this be requested. Now I will ask the lawyers representing QIA, BIMC, and the GN to identify themselves. And I'll start with Jeff.
Good morning. My name is Jeff Langwa. I'm counsel for QIA, along with Aria Laskin and Jessica Black. Aria and I are located in Vancouver. Jessica Black is located in Victoria.
Thank you, Jeff. I'd now like to ask Matthew to introduce his associates for BIM.
Good morning. My name is Matthew Halpin. I'm a partner with law firm Norton Rose Fulbright. I'm based in Ottawa, Ontario. I represent BIMC together with my colleague, Jenan de Young. Jenan de Young also works out of the Norton Rose Ottawa office with me. Thank you.
Thank you, Matthew. And now the Governor of Nunavut, and I'll start with Jane.
Thank you, Mr. Chair. Good morning, everyone. I am counsel for the Government of Nunavut in these appeals, along with my co-counsel, Mr. Ryan Baxter. We are located in Halifax, Nova Scotia.
Okay, thank you very much, Jane. The technical aspects of this digital hearing are being managed by Bruno Silva. Mr. Silva, can you please identify yourself?
I am Bruno Silva, so I'm going to be in the background. You will not be seeing me on camera, but I will be doing the live stream. Any technical issues, you can reach me on the chat, or you can always drop me an email. Thank you.
Thanks, Bruno. So we've all been through Zooms this year, obviously, and sometimes there are problems. If that happens and we encounter a technical problem which requires resolution, we will adjourn so that that Zoom host will reach out to those who may be affected in order to correct the problem. We hope that we won't have any problems, but as we all know, anything can happen. Before we begin, I would like to say a few words about the hearing process. We all understand the importance of the issues which are presented. We expect to reserve judgment at the conclusion of the public hearing next week in order to prepare a written decision as required by the Property Assessment and Taxation Act. We appreciate that we have experienced counsel representing all the parties before us and that a great deal of work has gone into the preparation for this hearing. The work which has preceded this public hearing means that we will not be hearing from witnesses this week. This is because there is consensus between the parties that the evidence presented to the tribunal in these appeals would be in writing. As a result of this consensus, the parties have already provided evidence in writing in three ways. By agreed facts, agreed by QAA, BIMC, and the GN, by affidavits filed by QAA, BIMC, and GN, and by transcripts of cross-examination on affidavits. GN and BIMC have also filed notices of question of constitutional law. As a result of the work which has gone into this already, we are sitting this week to hear final arguments from the lawyers for each of the parties. The panel understands that all parties agreed to the following sequence for the hearing. QIA will deliver oral arguments to the panel first. When the lawyer for QIA finishes their submission, then tribunal counsel may ask questions of that lawyer. Then each of the panel members may ask questions of that lawyer. Counsel will have opportunity of comment on anything arising. Then the lawyers for the second BIMC will deliver oral argument to the panel. When the lawyer for the second appellant finishes, then tribunal counsel may ask questions, then each of the panel members may ask questions of that lawyer. Counsel will have opportunity of comment on anything arising. Then the lawyers for the respondent, GN, will deliver oral arguments to the panel. When the lawyer for the GN finishes, then tribunal counsel can ask questions, then each of the panel members ask questions of that lawyer. Counsel will have opportunity to comment on anything arising. QAA and BIMC get a reply, then the same sequence for questioning applies after the reply. Counsel will have the opportunity of comment on anything arising. As a result, we expect submissions and questions of each counsel to take approximately a day and a half, with reply from QIA and BIMC to conclude. Following a pre-hearing meeting held on April 15th, the parties conferred and agreed to jointly request that one panel member recuse himself or be recused from the panel as he is a current employee of the government of Nunavut. Out of respect for the joint request, that panel member has voluntarily recused himself from the public hearing without necessity of determination of the merit of this request. Counsel from the GN has asked to speak to this briefly. Ms. O'Neill, do you wish to speak to this given the panel's decision?
Thank you, Mr. Chair. The only thing we'd like to add is that all parties have also agreed that their remaining panel members, there is no objection at this time to their sitting on the panel.
Thank you very much, Ms. O'Neill. Counsel for QAA, are you ready to begin your submissions?
I am, yes. Give me
Please
one
proceed.
moment. I just need to set myself up with sharing my screen.
Okay.
Mr. Chair, just a housekeeping question. Would it be amenable to the panel or permissible from the panel that while we're not making submissions that we have our cameras turned off?
I leave that to your own discretion. I have no problem with that whatsoever. And I'd like to further comment that please mute your mic when somebody else is presenting.
Certainly, thank you.
Thank you, Ms. O'Neill.
Can everybody see the PowerPoint slide I've now put up? Great. Well, thanks and good morning, everybody. As the chair has mentioned, we as counsel for the Qikiqtani Inuit Association will be presenting first. I anticipate that our presentation will take all of today and perhaps a small amount of time tomorrow before questioning is to occur. For today, we've got a PowerPoint slide deck that I've shared with you. Our intention is that this is going to be used to guide our submissions. It roughly tracks our written argument, but I won't be taking you to every portion of our written argument. You'll see, as you can see at the bottom of this first slide, that we've provided references for essentially every slide that we have here. There'll be references both to evidence as well as to references as to about where we are in our written submissions. There's probably only one outside document that's I'd ask that you have handy. And as you're obviously aware by this point, this appeal relates to rather it relates to the interpretation of Article 22 of the Nunavut Agreement. You'll be seeing me flash sections of the Nunavut Agreement up constantly during this presentation, but you may wish to have, in particular, Article 22 of the Nunavut Agreement. That can be located in the Joint Book of Authorities filed by QIA and BIMC. The agreement itself is at tab 46, and the Article 22 starts at page 2140 of the PDF of that joint book. We set up time, as the chair has mentioned, to ask questions tomorrow. I invite questions as I go through my PowerPoint presentation if there's anything that requires clarity in the moment. But unless there are questions, I don't intend to bring you to documents outside of what you'll see on our PowerPoint submission this morning. So as we've mentioned, we're counsel for QIA. I'm sure the panel is aware of what QIA is. QIA is a designated Inuit organization under the Nunavut Agreement. QIA is the owner of these Inuit-owned lands that are at issue in this proceeding. They own those lands through the Nunavut Agreement. QIA is tasked with representing over half of the Inuits in Nunavut. To begin our presentation today, I want to be really clear about why QIA is here. And I want to be very clear about that at the outset. First and foremost, QIA is here to protect Inuit-owned land, to protect the rights afforded to Inuit under the Nunavut Agreement, and to ensure that the Nunavut Agreement is properly interpreted and properly implemented. That desire brings us here to file an appeal against the government's attempts to impose property taxation against Inuit-owned land, against QIA, in relation to lands where the government does not provide any local government services or improvements. As we'll discuss, the Nunavut Agreement sets out limits, in our view, on the government's ability to impose taxation. QIA's perspective is that property taxes, real property taxes, may only be imposed on improved Inuit-owned lands in the general taxation area for local government services or improvements. That's the exact language used in the Nunavut Agreement, and we're going to spend quite a bit of time going through the words themselves. QIA's perspective is that Inuit did not agree to pay property tax on Inuit land to fund broad territorial expenditures far removed from Inuit and Inuit-owned lands. Yet that's precisely what the government now seeks to impose through the taxation assessments that are under appeal. I want to be clear, QIA is not here to attempt to receive a windfall or to create a windfall for Baffin land. We're not here to protect BIMC's interest in the land. BIMC is QIA's tenant of these lands, But the interpretation of the Nunavut agreements that the tribunal arrives at in this proceeding is going to apply to all Inuit lands forever, or at least until the Nunavut agreement is amended. Nor is QIA here to attempt to skirt its responsibility as the largest landowner in the territory aside from the Crown. What we're going to be suggesting in this argument is that there are certain Inuit-owned lands that are not subject to property taxation unless the government provides services and improvements to those lands. But as we'll demonstrate, this is going to have only a limited impact. This is not going to impact the imposition of property taxation on Inuit-owned lands situated near communities, situated in areas where the government is providing services or improvements. Instead, we're here because the government is attempting to impose a very large tax bill on QIA, on Inuit, without providing any benefit to those Inuit lands. Now, in these submissions, as you'll see, we're asking the tribunal to undertake a fairly complex task. The nature of this appeal is slightly different than many other appeals that might arrive before an assessment tribunal. We're asking the tribunal to conduct the first judicial interpretation of Article 22 of the Nunavut Land Claims Agreement. As I've said, our main interest is ensuring the proper interpretation and implementation of the agreement, and in particular, to ensure that that interpretation serves Inuit interests and protects Inuit rights to land. Here's the key issue. Can the territorial government impose property tax on remote Inuit lands without providing any services or improvements to those lands? As I've said, this is a complex issue, but if there's a saving grace here, it's that the parties have worked very hard to limit the matters that are in dispute before this tribunal. The parties essentially do not disagree on the facts at issue in this case. There's no factual disputes on the key points in issue. The parties agree that these Inuit lands are outside of municipal areas. The closest population center is 155 kilometers away as the crow flies. There are no local government services or improvements provided to these lands. As you'll hear, BIMC funds all services to these lands. And therefore, any tax revenue GN collects from these lands will go into its general revenue account to be spent on any number of territorial initiatives far removed from these lands. As you'll hear from us today, there is in a very real sense no local government presence in this remote area. As I've said, you're going to be required to interpret Article 22. This matter of legal interpretation will take some time to work through, but this said, our position is that the key issue involving the interpretation of Article 22, and in particular, the definition of real property tax, is relatively simple. Now I say that, and I hope that you don't sort of look at me askance, because you've now been through hundreds of pages of arguments. You've seen the amount of material that's been filed by the parties. But I do say that the words mean what they say, and we're going to spend some time showing you that. What we're going to show is that the Nunavut Agreement created a new kind of land, Inuit-owned land, and a new property tax regime to go along with it. Overall, this regime provides significant limitations on the application of real property tax to Inuit-owned land. It's different than the property tax regime that applies to private lands in Nunavut. We're going to discuss these limitations, but the key point is going to be that while the government can impose taxes on improved Inuit lands, those taxes must be imposed for local government services or improvements. Our position is that local government services or improvements must be provided locally in order to impose real property tax on Inuit-owned lands. You're going to hear this quite a few times today. But at the end of the day, our argument is that the words of Article 22, and in particular the real property tax definition, are understandable. We're going to show you their ordinary meaning. And we say their ordinary meaning is that the government may tax improved Inuit-owned lands, but it must justify that tax by providing services or improvements in relation to those lands. That is the deal that was struck between Inuit and Crown negotiators. And as we'll argue, the tribunal's main task is to ensure that the choice of the words that the negotiators made are respected. It was a hard-fought negotiation to get to finalize the Nunavut agreement, and we are going to show why our interpretation respects that language. As I mentioned, we've placed a very important burden on this tribunal. The Nunavut agreement has been in place for over 20 years, but courts and administrative tribunals have not had many opportunities to interpret it. The interpretation of Article 22, as with any section of the Nunavut agreement, is critical to ensuring that the treaty continues to be implemented and continues to be honored. These modern treaties impose obligations on Inuit and impose obligations on the Crown. They change the relationship between the parties. Undertaking an interpretation of this agreement requires considerable care, but happily, as will be my submission, the courts have provided clear guidance about interpreting modern treaties. Their guidance has been that care is required, close attention to the terms of a treaty is required, and that the tribunal should strive to respect the handiwork of the parties that negotiated the treaty. During these submissions, we'll take you through those principles. So my sort of one final apology here, which is the notices of appeal, as well as the notices of constitutional question that you've gone through. At the outset of this appeal, listed a number of questions that would be involved in this appeal. I think it's the case that he's probably cast the appeal a bit more broadly than it likely needed to be. At the end of the day, we have a very modest request to make of the tribunal, and one that's squarely within your powers to make. If you agree that the government cannot impose tax without providing services or improvements to these Inuit-owned lands, we simply ask that you order the cancellation of the notices of assessment that are under appeal. What we'll show is that this isn't a radical measure. Indeed, every single year, the government of Nunavut has to selectively apply its territorial taxation law so as to not run offside the Nunavut agreement. Here, we are only asking for assessments for this particular property to be canceled for these particular years under appeal. So here's the submissions that you're going to be hearing today at a high level. And I should mention that Ari Alaskan will be assisting with a number of these points. We'll be trading off during the day. So this is a high-level outline. We've got this slide a number of places throughout our presentation to make sure that you're situated and where we're at in our argument. And as we go through the day, we've got some other signposts to guide you along in our argument. But at a high level, what we intend to do is first describe the Mary River Inuit lands. Second, I then want to spend time with the Nunavut agreements. We have a common understanding of the nature of Inuit-owned lands and the tax regime that applies to them. Number 3 here is our big item. And as we get to this item, I'm going to provide you some other headings and guideposts to show you how we're making this argument. This is going to be our main submission today. And this will describe what QIA's interpretation of Article 22 is, with the goal of determining when are Inuit-owned lands subject to assessment and taxation. Point 4, and this is our final point, which we'll likely come to tomorrow. I'm going to summarize our argument, describe the implications for these particular tax assessments. Now, one note before we move on. Our notice of appeal lists 3 issues, and the outline I've given you really only speaks to our first issue. Are these lands taxable? That's the threshold question. Our notice of appeal also takes issue with the amount of the assessed value. We will defer to our friends from Baffinland who are going to be advancing those arguments. We have some small notes in our written submission that I can point you to, but in the main, that will be Baffinland's job. Next, our initial notice of appeal had appealed another question, and that was, is QIA the properly assessed owner of the land and improvements for the Mary River Inuit lands? What you'll see from our written submission is that we no longer advance this ground of appeal. That means the tribunal does not need to make determinations on that issue in this proceeding. So you won't hear me speak to it today, and you'll only find a relatively minor note in our written submission in regard to that issue. This at a high level is what we're going to show you. First, the Mary River lands are Inuit lands with no government funded services or improvements. Second, we're going to show that the Nunavut Agreement guarantees a broad tax exemption for Inuit lands with only limited exceptions, and it's the exceptions that we're going to spend most of our day on. Third, we'll argue that Inuit-owned lands outside of municipalities are exempt unless they are 1, improved, and there's no issue here, these lands are improved, but 2, we say they must be provided with local government services or improvements. Finally, to wrap up, we're going to argue that because there are no local government services or improvements, these particular lands are exempt from real property taxation for the years that have been assessed. So we'll begin with our first area of argument. What are the Mary River Inuit lands? And I will hand the mic over to Ari Alaskan to bring you through this section. I'll join you again when we get down to issue number 2.
Hi all. Jeff, if you go to the next slide. I want to start by situating our hearing in the actual lands that we're talking about. Much of what I have to say here may be familiar to some of you or to all of you, but I ask you to bear with me so we're all on the same page. If you want to follow in our written submissions, I'm at around paragraph 17. So as you can see from this slide here, the Mary River Inuit lands are located in the middle of the northern end of Qikiqtaaluk or Baffinland. And you can see like I said, you can see their rough location there. And they're located in what is called the general taxation area of Nunavut, which is effectively everywhere outside of Iqaluit. Jeff, can you go to the next slide? As you saw on the previous slide, these lands are incredibly isolated. There are no nearby communities. The 5 closest communities range from about 155 kilometers to 415 kilometers away. And as I'm sure you're all aware, that 155 kilometers is a really significant distance in the absence of roads. There is no factual dispute on this point between any of the parties. These lands are very much isolated, very much on their own, far outside of any municipalities, hamlets, or communities. Next. So here we'll look more specifically at the actual lands in question. As you'll see from this slide, we're looking at 3 parcels. You see P119 kind of to the north, and then P116 and P117. Those are the 3 parcels that we're talking about. The Mary River lands are Inuit lands, and you're going to hear more from my colleague about what that means, but I'll give you a little bit for now. The surface rights on all 3 of these parcels are owned by QIA, but it's important for the tribunal to recognize that QIA, as a designated Inuit organization, or DIO, as we'll refer to those organizations, is not the same as a private landowner. Inuit lands are not the same as lands held privately in fee simple. As I said, you're going to hear more about this from my colleague later today. And as well, I urge you to look at Appendix C of QIA's written submissions, which provides a little bit more information about the governance structure among and between DIOs in Nunavut. But for now, the point is that the surface rights to these lands are owned by QIA, but they're owned for the benefit of all Inuit in the Qikiqtani region. So they are, in a way, held for the benefit of Inuit there. The 3 parcels in discussion are leased by QIA to BIMC, which owns and operates an iron ore mine on the lands. And you can see the mine location. It's mostly on parcel P117. Next. We won't go into this in detail for the purposes of this appeal, but for the tribunal's reference, Inuit own only a very small fraction of the subsurface or mineral rights on Inuit land. So although about 16% of Inuit lands, the Inuit own the surface rights, they only own subsurface rights on about 2% of land in the territory. That interest is owned by Nunavut Tungavik Inc., or NTI. I know a lot of you are familiar with NTI, but again, to make sure we're all on the same page, and this section's all at paragraphs 48 to 50 of QIA's written submissions. NTI is the Nunavut Inuit Representative Organization operating at the territorial level. It's responsible for broader territory-wide governance for Nunavut Inuit, and it has a central role in administering and implementing the Nunavut Agreement. Beneath NTI are 3 regional DIOs, which each represent a region. Nunavut split into 3, and as you heard from my colleague earlier, QIA represents the Qikiqtani region, where 51% of Inuit live. So going back to this mineral rights point, NTI owns the mineral rights on that 2% of lands. But then there's an even smaller subset of lands, less than 1%, on which the mineral rights are owned by NTI for the benefit of all Inuit, but they aren't administered by NTI. They're administered by the Crown. And where the mine is on parcel P117 actually falls into that very, very, very small subcategory of land. Next. What does that mean to own rights that are still administered by the Crown? Well, it means that while Inuit own the subsurface rights on those lands, and in this case on the lands where the mine is located, they don't control them. Before entering into the Nunavut Agreement, the Crown leased the mineral rights on that land to another company. The rights have subsequently been acquired by BIMC. The Crown continues to administer them. So while Inuit own them, they don't control what happens to them. All they can control is the surface rights. Next. Another just quick point to note is that Inuit don't at this point receive any royalties from those lands because of how the grandfathered mineral scheme works at this point. And this, again, you don't need to turn to it, but it's at our written submissions at paragraph 17. So there's a obvious question here. Where are the benefits to Inuit from permitting BIMC to operate this mine? They're not getting royalties. Well, they come from 2 places. First, they come from the lease, and we'll discuss that in a moment. But there is a lease between BIMC and QIA for the use of those lands, because like I said, the only thing that QIA does control is at this point is the surface rights on the Mary River lands. Second, Inuit receive benefits under what's called an Inuit Impact Benefit Agreement, or IIBA, with BIMC. I imagine, as most of you have heard of that. The mine presents economic opportunities like training, employment, and contracting, all of which are addressed through the IIBA. These opportunities are intended to benefit the Inuit living closest to the mine. But again, no one lives too close in terms of physical distance because of the mine's isolated location. Next. Turning then to the lease. Like I said, BIMC and QIA have a commercial lease that permits BIMC to operate its mine on the Mary River Inuit lands. And I want to make very clear and situate up front for the tribunal that the lease is totally irrelevant to your purposes. The reason that I'm talking about, because, and I should say why, it's irrelevant because the question for you is the interpretation of the Nunavut agreement. It's not the interpretation of a private lease between private parties, which is a commercial arrangement. The lease doesn't matter. An obvious question you're thinking is, if it doesn't matter, why are you talking about it? Well, the reason I'm talking about it is because in their written submissions, the government of Nunavut appears to functionally rely on this lease as kind of an argument or proof that the parties expected to pay property taxes, because there's a provision in the lease that requires BIMC to pay, quote, all rates, taxes, charges, and assessments charged in respect of the property. And so we will go through in a little bit more detail this afternoon why, as a matter of law, anything the lease says is irrelevant for the purposes of this case. But I did want to give you a bit of factual context behind that type of term, so just so the tribunal understands its inclusion and why it doesn't do what the government of Nunavut says it does. First thing to mention, this is a standard form term that is included in triple net leases like this one, which just means that in addition to rent, the lessee promises to pay all of the expenses related to the property. You know, it's a catch-all term, and as you'll see, there's no specific mention of, it's not property tax on its own. It's basically everything. And as I'm sure you'll hear from my friends at BIMC tomorrow, in practice, BIMC does pay a fair amount of taxes related to the property. Inclusion of the term made particular sense in light of the context that when the lease was being negotiated in 2012, it was ultimately entered into in 2013, there was a real prospect that the government of Nunavut would eventually be providing some type of government services and improvements in and around the mine area. And the reason that the way we can see that here is from, we have an excerpt here from the NERB report from 2012. So the regulatory hearing that preceded the mine actually opening. This is an excerpt from that. And we see Baffinland indicated that although it would develop most of the infrastructure and provide most services, some incremental project-related costs would be imposed directly and indirectly upon public infrastructure and services. Baffinland noted that the cost of this use in the case of the Mary River project would be, quote, paid for through taxation, and that these contributions would more than outweigh project-related use of public services and facilities. So as BIMC said at the time, in the event that there were public infrastructure and services provided in and around the Mary River Inuit lands, well, then there would be property taxes. They would be covered, that would, functionally cover the cost of those services. And as you will hear, there is no factual dispute that this did not happen. There are no such services or infrastructure on the site provided by the government of Nunavut. If there were, we wouldn't be here. But because there aren't, that's why the question before you is, in the absence of any services, can the government of Nunavut still tax those lands? But the factual situation we're in now wasn't clear when the lease was entered into, and it does cover that eventuality. Next. The government of Nunavut also says that this tax is really for Inuit benefit. I won't dwell on this point, but it's important for the tribunal to keep in mind whose name is on the tax bill. It's not BIMC's, it's QIA's, which is functionally saying the Qikiqtani Inuit. If BIMC goes bankrupt or leaves the territory, which is a real risk, as I'm sure members of this panel are well aware of the risks associated with mining in Nunavut, it's QIA who's ultimately liable. And the annual taxes take up well over 75% of the annual rent, which is about $3 million. You can see here in 2016, they were nearly the same number, but that number does vary year to year. Next slide. I also want to note quickly, where does the tax bill come from? Where does the, where does the amount of property tax owed, as I'm sure you all know, is determined with reference to a property's assessed value. So the assessment value is what drives the actual tax bill. And I show this to you because I'd like you to see, where does the assessed value come from? If you look at the assessment here, you'll see that the land itself is assessed at about $3 million, which is less than 2% of the assessed value. So where does the value come from? Well, 187 million, or more than 98% of the assessed value, comes from BIMC's improvements. And those are improvements, like that's for mining, that's for the mine. They're not for the direct benefit of Inuit. I do understand that this number has dropped a little bit, or there's an agreement between BIMC and the government of Nunavut for the improvements to be more like 178 million, and I'm sure you'll hear about that tomorrow. But the grossly imbalanced nature of the split remains. The tax bill for these lands comes from BIMC's improvements or BIMC's benefit, not for Inuit. Next. I want to conclude this section before giving you back to my colleague by briefly addressing what type of services are actually provided on these lands and by who. Now, something important to note for this section is we have no dispute between the parties. Everyone agrees. These facts are not contested. It's more what you do with them that is the point of dispute. The government of Nunavut does not provide services and improvements on or around the Mary River lands. And the excerpt you see here is from the agreed statement of facts. So that's the document where all the parties agree, yes, this is all true. The Mary River project's not located within a municipality. There are no municipalities or hamlets within the project lands. Further, there are no schools within 150 kilometers. There are no hospitals within 150 kilometers. GN doesn't provide water, sewer, drainage systems, doesn't provide waste disposal services, doesn't provide ambulatory or emergency firefighting services. And then Baffinland is responsible for maintaining the tote road, which, we're past that slide now. We don't have to go back to it. You'll have seen there's a little red road that kind of goes through the whole area. And that's the road there that Baffinland maintains. So, what is the take-home message here? So that GN doesn't provide what we think of as local services and improvements in the area. No schools, hospitals, water, sewage, waste disposal, ambulatory, fire services, roads, the types of things that we think of as local services. Next. So who does provide those services? Well, to a large extent, like I said, no one not working on the mine is living or working in that area. So there don't have to be stuff like schools. But to the extent services are required, they're provided by BIMC. BIMC provides services like water, sewage, ambulatory, fire prevention, road maintenance. So really, to the extent that there are services in or around the Mary River Inuit lands that look like local services, they are not publicly funded. So I think I'll end my remarks for now there, but the key point for you to remember here is that everyone agrees the Mary River Inuit lands are isolated and they do not receive anything that looks like a local service or improvement funded by the government of Nunavut. Over to you.
Thanks. So we're going to move on now to the second section of our submissions. In this section, we want to provide you an overview of the Nunavut Agreement in particular, to describe what are Inuit-owned lands. Then I want to spend some time talking about the taxation regime that applies to Inuit-owned lands. I'm going to spend time giving you a little tour of Article 22. It's a brief section. I'm sure you've all read it at this point. And then I also want to talk about PATA. And my main point there is going to be that PATA is not of very much assistance in resolving this dispute. The government of Nunavut has not implemented Article 22, has not included the various exemptions owing to Inuit land in PATA. We can't get into the importance of the Nunavut Agreement without understanding what came before. Prior to the Nunavut Agreement being negotiated and put into place, Inuit homelands were located within the jurisdiction of the Northwest Territories. At that time, control of all of this Inuit territory rested with a distant Ottawa government. It was managed primarily for outside interests with little regard for Inuit, their culture, their way of life, or their future on these lands. Inuit, beginning much earlier than the 1970s, but certainly leading up to the 1970s, politically organized, pushed the Crown for a new arrangement with Inuit and pushed the Crown to resolve long-standing issues with distant Crown control over Inuit lands, over the fact that the Crown had not recognized Inuits' right to lands, Inuits' right to their culture, way of life, and practices. This led to a long negotiation of the Nunavut Agreement. Through the 1970s and up to the early 1990s, this agreement was negotiated. It was negotiated by teams of negotiators for both Inuit and the Crown, teams of lawyers tasked with assisting with those negotiations and ultimately drafting the agreement. You'll see in the previous photos many people, but many, many more were involved on behalf of both Inuit and the Crown. This agreement fundamentally reshaped both the region and Canada. It recognized a broad suite of Inuit rights. Today, we're only going to be concerned with Inuit rights to land and the rights and obligations of both Inuit and the Crown in respect of those lands. It also created Nunavut. But make no mistake, Inuit paid a considerable price to obtain that Crown recognition of their rights. In particular, in relation to land, Inuit exchanged their claim to Inuit title and asserted rights to the land, to their asserted rights to govern the territory for a relatively small share of the overall land base. This makes the protections that Inuit received for this land all the more important. And the tax regime I characterize as one type of rights that were recognized. Inuit were granted a different sort of tax regime than applies to private lands within Nunavut. My colleague, Ms. Laskin, discussed this to some extent, but you'll see the deal that was struck here was that Inuit would receive a relatively small portion of the land within Nunavut, about 18%. The agreement recognizes their title and surrenders title to the remaining 82%. Mineral ownership is even more unbalanced. The Crown overwhelmingly owns the mineral rights within Nunavut, 98%. You've seen the location of Inuit lands. Previously, I won't spend much time with this. But the agreement itself deals extensively with land. Articles 17 to 22 describe a bunch of different facets of Inuit land. The primary purpose for Inuit lands was to provide a land base for both culture and self-reliance to get away from dependency on the government. In our written submission at paragraphs 29 to 33, we go into more depth about Inuit land rights. But the key features are these. First, Inuit-owned lands are not the same as private lands owned by individuals in Nunavut. while DIOs like Kikikitani Inuit Association hold the actual title to these lands are not permitted to be sold. Instead, DIOs are tasked with managing Inuit lands for the collective benefit of all Inuit that are here today and future generations. QIA, like other DIOs, has to manage these lands to fulfill different and sometimes competing purposes. These include purposes for community purposes, for economic development, like mining, as these lands have been put to, and for the exercise of Inuit harvesting rights and for preservation of other areas that are important to Inuit. These lands were carefully selected on the basis of these values and are carefully managed by DIOs for these purposes. So next, I'd like to just turn to the tax regime that applies to those Inuit lands. There's two main pieces to this framework in Nunavut. There's the agreement, and I'll take you through that now, and next I'm going to take you through territorial legislation. I'm going to start by walking you through Article 22. You're probably all well familiar with it by this point, but if we spend more time with this exercise now, I think we'll move through our main submissions on the interpretation of those sections somewhat more quickly. So, to begin, the key point is that the parties agreed that Inuit-owned lands would be subject to a very different property tax regime. Paragraphs 38 and 40 of our written submissions, we set out some of the background negotiating history. There were diverging views at the start of this negotiation of the Nunavut Agreement that were expressed by the parties. In a broad sense, at the beginning of negotiations, the Crown wished for these lands to be taxed like all other private lands. Inuit had concerns about that. Inuits had concerns particularly given the experience of other Indigenous people, primarily Indigenous people in Alaska, who at the time negotiations were ongoing with Inuit, had gone through a difficult circumstance where land rights in Alaska for Indigenous nations were recognized, but they were subject to property taxation. On occasions, those taxes weren't paid, and a number of those communities had their lands executed against, seized, and sold in order to satisfy tax judgments. Inuit, at the start of negotiations in relation to the Nunavut Agreement, expressed a concern about Inuit land rights being eroded, and perhaps being eroded quickly if they were subject to broad property taxation and if they weren't able to pay those taxes. So ultimately, I'm not here pointing out that history to say we have to interpret the Nunavut Agreement in light of that. What I'm pointing towards is there was a compromise reached between those positions, between full taxation and no taxation. This was a compromise reached through very hard-fought negotiations over literally decades. So I'm going to show you that compromise now. The first part of this compromise is that there was an extremely broad exemption granted to Inuit-owned lands. I've put Article 22.2.1 on the screen. This section constitutes just a blanket exemption. Any legislation out there that sought to impose property tax on land does not apply to Inuit-owned lands. Inuit lands were exempted broadly from taxation. They can't be taxed by municipal, territorial, federal governments unless permitted by Article 22. And Article 22 does permit taxation. I'll walk you through two sections now. The reason there's two sections is that there's two different taxing authorities. This first section deals with Inuit lands within municipal boundaries. This slide here shows that Inuit lands within municipal boundaries can be taxed. At present, this only applies within Iqaluit. This is not the issue for Mary River lands, but Inuit-owned lands in Iqaluit, they can be taxed so long as they are improved or essentially available to be improved. But I want to note, this is not any kind of taxation as the government sees fit. It's specifically, and I'll note the words, shall be subject to real property taxation. I'm going to say the words real property taxation probably 1,000 times today. But that is what the lands are subject to. It's real property taxation. And in a moment, I'll explain what that is. Second, and this is the section that applies in this appeal, for lands outside of the authority of municipal taxing authority, so in the general taxation area, those Inuit-owned lands are also subject to real property taxation, provided that they are improved. Unimproved Inuit lands in the general taxation area are not subject to real property taxation, but improved lands, as the Mary River lands are subject to real property taxation. So what is real property taxation? This is what the entire case turns on. Real property taxation is a defined term in the Nunavut Agreement. This is really critical. The effect of defining this term is that every time you read the term real property taxation, you must look at this definition. This is what it means. It's not permissible for the legislature to pass legislation that makes up a new definition for real property taxation. Nor is the term real property taxation defined in the same way as property taxation is in the Territorial Assessment and Taxation Act. Instead, it's the Nunavut Agreement that defines it specifically and which prevails over territorial legislation. So the upshot of this is that the only taxation that can be imposed on Indian-owned lands is real property taxation, as defined here. I'm not going to dwell on the specific words now, because that'll be the large part of the submissions to come. But the key point is it's only real property taxation that applies to Inuit-owned lands in the general taxation area. Now, the next stop on our tour here. So we have a broad exemption. We have some narrow exceptions that allow for real property taxation. But there are additional carve-outs for specific sorts of improvements. So while improved Inuit-owned land can be taxed both in the municipal areas and the general taxation areas, Inuit secured additional exemptions for specific kinds of improvements. This section just means that certain improvements won't count as improvements for the purpose of assessing and taxing Inuit-owned lands. And what you'll see here is Inuit said, fine, we will agree that our improved lands can be subject to real property taxation, but certain improvements shouldn't be counted as improvements. They're valuable for the maintenance of Inuit culture, life. They shouldn't be subject to taxation, and the government agreed. This is not the issue in this appeal, but I'm going to raise this again when I start talking about the Property Assessments Taxation Act. Next, there's another protection built in for Inuit-owned lands. I mentioned earlier that Inuit concern at the time of negotiating the treaty was that Inuit lands be protected from seizure in the case that taxes were unpaid. But this, again, does not mean that Inuit do not have to pay taxes. If there are tax arrears, this provides that the taxation authority can still seek to collect those taxes. They don't do this by, in the normal course, by executing and trying to sell lands. They can't do that. But they can seize the personal property of QIA, and they can seek to execute against the Nunavut Trust itself. That's the trust that's holding settlement funds that were provided under the Nunavut Agreement. So earlier, my colleague, Ms. Laskin, mentioned this. The tax bill that has been delivered here by the government has been delivered to QIA. It is QIA that will be subject to taxation. It is QIA that, if you uphold the government of Nunavut's attempt to tax these lands, that will owe literally millions of dollars in taxes. Now, there is an ability under the lease to have Baffinland pay those taxes. It's their obligation to do so. But as you've all heard, and especially in the news recently, there are risks to this sort of venture. Should Baffinland leave the territory, it will be QIA that is holding the bag. And what happens in that event? The government can't seize Inuit lands, but they can come after QIA for its own personal property, and importantly, can come after the assets of the Nunavut Trust. That's the risk that we face in this appeal. $180 million of improvements have been assessed as the approximate value of those improvements. A tax bill is going to be delivered to QIA based on that assessment. And this is the risk that QIA faces. I'm going to move now to a brief discussion of PATA. So this is your enabling legislation. I'm sure you're all very familiar with it. It's the law of general application governing the assessment and taxation of property in Nunavut. Its origins, however, are in the NWT. PATA was, at the time Nunavut was created, PATA existed in the NWT in essentially an identical form to the Nunavut law that now exists. At the time that Nunavut was created, it needed laws. And so in many instances, and this is one of them, they copied the NWT Act and enacted it in Nunavut. In this case, they did so with very few amendments to the Act. And as I'll discuss, this, I think, causes significant issues. Importantly, PATA's never been updated to correspond with the Nunavut Agreement. So we've just shown you a number of exemptions that exist for Inuit-owned land. Unimproved Inuit-owned land in the general taxation area can't be taxed. Certain kinds of improvements cannot be taxed. In light of these sections, one would have thought that the main taxation statute for the territory would have been updated to refer to those exemptions. But that's never occurred. Over almost 30 years now since this agreement was signed, this territorial law of general application has never been updated. It doesn't mention the Nunavut Agreement. It doesn't mention Inuit-owned lands at all. I won't take you there now, but the curious thing about PATA as it existed in the Northwest Territories prior to it being copied over into Nunavut legislation was that PATA did in fact deal with a number of exemptions that were provided to Indigenous lands in the NWT. Importantly for the Inuvialuit, which is the Inuit population in the Western Arctic, situated near Inuvik, they had negotiated one of the first land claim agreements in Canada, and that land claim agreement provided them a land base. In some ways similar to the land base provided to Inuit in Nunavut, there were a number of exemptions from property taxation for those lands. PATA and the NWT specifically provided exemptions for those lands. So in the NWT, an assessor looking to determine who to assess for property tax could look at the legislation, and it would say, I'll bring you to the section here. This is PATA currently, but in the NWT, PATA was written in a way that required assessments and taxation of property unless otherwise exempted, and it provided exemptions to the Inuvialuit. When that act was copied over to the NWT, they simply removed the references to Inuvialuit and did not replace them with the exemptions that were clearly provided within Article 22. So this is the presently existing PATA, Section 5. Section 5 states that all land is liable to assessment unless it's exempted. Section 73, which I'll flip to quickly here, states that states a number of exemptions from taxation. Section 4 sets out a number of exemptions from assessment. And you'll see at the top of this slide here a number of repeals. These were the sections that recognized the exemptions that applied for Inuvialuit lands, but they did not, when they copied this legislation over, insert the clear exemptions that are provided in Article 22. So when we look at Section 5, It says, subject to Section 4, all land is liable to assessment. Well, is that true in Nunavut? It's absolutely not true. There is a host of unimproved Inuit-owned lands that are not subject to assessment. You wouldn't know from looking at PATA. What about improvements like outposts and traditional camps that are exempted in Article 22? You wouldn't know this from PATA. So what does this mean? Why am I raising it? PATA is not applied routinely by GN's assessors when they are looking at Inuit-owned lands. Each year, when Inuit's assessors are putting together annual assessments in relation to almost 20% of the territory, they can't be guided by PATA. Instead, they're functionally doing what we're asking you to do in this appeal. They look at Article 22 and they interpret it, and they try to determine whether there is an exemption that exists in Article 22 outside of PATA, whether there's an exemption for IOL that prevails over PATA's outdated directions to assess and tax all land and improvements. I raise this because we're asking in this appeal for you to do precisely what the assessor does every year, which is look at Article 22, determine the scope and nature of the exemptions granted to real property taxation for IOL, and then determine whether or not a piece of property is assessable. Here, we say the government of Nunavut's assessors made an error. They haven't appreciated that Inuit-owned lands are only subject to real property taxation, and as we'll argue, that is very limited. So, you know, I look at PATA as somewhat of a dinosaur legislation. It's not reliable in determining whether or not Inuit-owned land is taxable. To do that, to do that task, you need to look at Article 22. This legislation needs to be updated. That's beyond the tribunal's powers and jurisdiction. Your power and jurisdiction, as we'll discuss later on, is to conduct an interpretation, as do GN's assessors each year, of Article 22 and determine whether or not the lands at issue here are exempt from taxation in these circumstances. So now we're going to move on to our main issue. And that is, when are Inuit-owned lands in the general taxation area that are improved, when are those taxable? This is going to be a fairly lengthy submission, but we've broken it down into a number of pieces. The first thing we're going to do is discuss what are the principles of interpretation. When courts, regulatory tribunals like your own, when decision makers are looking at legislation or agreements, what are the rules to follow? How do we know, how do we determine what words mean, what provisions mean? We're going to walk you through the principles that we'll ask you to follow in this case. Following that, we're going to turn to QIA's interpretation. You've seen our interpretation already. Our interpretation is that improved Inuit-owned land can only be can only have on it imposed real property taxation, and that requires that there are local government services or improvements that are provided in relation to those lands. That's the threshold question. Following our interpretation, that's going to be a fairly lengthy section that I'll break down into some additional pieces. We're going to argue that PATA, by requiring assessment and taxation of these lands in these circumstances, is inconsistent with Article 22, and that the Nunavut Agreement prevails. So first, we'll start with principles of interpretation. Chair, what I was going to suggest, you mentioned earlier that you would like to take perhaps a break before lunch at some point. What I was going to suggest is that we undertake sort of our 3A submission, which I think will take about a half an hour. And we could take a break at that point before moving on, but I'm in your hands.
That sounds perfect, Jeff. Please continue. Thank you.
So principles of interpretation. Under this, we have two types of principles that we'll ask you to follow. The first are principles of statutory interpretation, and the second is principles that relate to the interpretation of modern treaties. So we'll start here with principles of statutory interpretation, and I'll ask Ms. Laskin to take this section of the submissions.
Hi again. So turning first to the principles of statutory interpretation. When we say statutory interpretation, what does that mean? Many cases, like the one before you, require decision makers like yourselves, so that the decision makers can be judges or administrative bodies like you, to interpret the words of a provision in a law, so just to interpret the words of their statute, and consider what it means, what the words legally require. That process is known as statutory interpretation. That's all that phrase means. But that process of reading a provision and understanding what it means is guided by a number of established principles, and we're going to go through those together now. Next. Jeff, sorry, next slide, please. Thanks. The quote you can see here is from a Supreme Court of Canada case that is relied on in basically every case ever after that, because it's seen as the seminal, the leading quote on how you do statutory interpretation. It's the #1 guideline. And I'll read it. Today, there is only one principle or approach, namely, the words of an act are to be read in their entire context and in their grammatical and an ordinary sense, harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. That's a long sentence. Let's break it down into 3 parts. What it really is saying is that there's 3 steps to statutory interpretation. Step #1 is grammatical and ordinary meaning, which we'll talk about in more detail, but literally means looking at the words and figuring out what they mean. Step #2 is the scheme or context of the provision. And we'll talk about that in more detail as well. But that really means, how does this one provision fit into the whole act as a whole? And then the final step is thinking about the object of the act and the intention of its drafters. What is the act trying to achieve? What is the whole goal of it? And then you think that the process for you is what interpretation best facilitates that goal, that aim. There's an additional component, and we'll go through this as well. This is just a summary slide. The implications of an interpretation. And that means you think about, well, if we adopt a particular interpretation, what happens? What is the outcome? What does that mean on the ground? I'm going to go through each of these steps in the statutory interpretation scheme right now. And if you want to follow along in the written submissions, they're at paragraph 73 of QIA's submissions. And it's a long paragraph, so they're all on 73. Next. So we'll start with the grammatical and ordinary meaning. And like I said, that's sort of a slightly convoluted and complicated way of saying something which really is pretty simple. Just means you look at the words, you read them, and you think about, well, what do they mean? There's a quote here. We've put in a number of quotes and references to a book by a woman named Professor Sullivan, and that's sort of the main book on statutory interpretation. So that's where this source comes from. And she writes, most often, ordinary meaning refers to the reader's first impression meaning, the understanding that spontaneously comes to mind when words are read in their immediate contexts. In the words of, this is Justice Gonthier, so in the words of the Supreme Court judge, the natural meaning which appears when the provision is simply read through. That's what you're looking for. The natural meaning which appears when the provision is simply read through. But because lawyers are never really that simple, I'll give you some of the principles that attach to how you think about natural meaning in that first step of statutory interpretation. Next. So we'll start with, what are the sources? What are you allowed to look to when you're considering what the ordinary meaning of a provision is? There's a lot of sources. You can start with your common sense understanding of the words, and frankly, I think that's where everyone starts. That's the natural thing to do. You can look at definitions. So sometimes a term will be defined in legislation. You can look at how the words were used in other cases. And you can look at dictionary meaning. You can see, oh, what does the dictionary say that this word means? But that comes with a caveat, which is that dictionary meaning is never really enough on its own. They're not good indicators of the range of meanings a word can bear. And statutory interpretation needs to take into account that possible range of meanings and then choose the best one. So dictionaries are a very useful starting point, but they are not the ending point as well. Next slide. Now, there's also a few presumptions that can be used to guide you, and they're called presumptions. That's the technical name for them, but a presumption, again, is just really a principle or a guiding way of reading a provision and trying to understand the words that are in it. And we'll go through some of those presumptions that have been previously applied. There are, I should say, many, many presumptions, but I'm only going to take you through 3 of them. I'm going to take you through the 3 that we say are the most important for you when you're interpreting Article 22. The first presumption, this is 2 bullets, but really it's 1, is that every word is necessary and every word has a specific meaning. And it's Professor Sullivan has described it this way: it is presumed that the legislature avoids superfluous or meaningless words, that it does not pointlessly repeat itself or speak in vain. Every word in a statute is presumed to make sense and to have a specific role to play in advancing the legislative purpose. So presumption number 1, every word has a meaning. No word is redundant. Next slide. Then here are the 2 additional presumptions, both of which are very important, and they're all kind of interconnected. So number 2 is the same words have the same meaning. That one's pretty simple. It means that when a word is used in more than one place in a provision or in an act, it means the same thing every time it is used. And again, this is referred to in short form as same words have same meaning. And then the corollary of that presumption, or the kind of offshot of it, is that different words have different meaning, which is again just means that when a different word is used in a provision, when 2 different words are used, they don't mean the same thing. And I'll just read this quote from Professor Sullivan as well, because I think it sheds some light on this presumption. Given the presumption of consistent expression, which is same word, same meaning, consistent expression being, the same word is used to mean the same thing every time you see it, it's possible to infer from the use of different words or a different form of expression that a different meaning was intended. As Justice Malone said in this case, when an act uses different words in relation to the same subject, such a choice by Parliament must be considered intentional and indicative of a change in meaning or a different meaning. And I'll just pause to give you a quick aside, which is to say, usually the interpretation is of a statute, so all the references are to Parliament and that kind of thing. In this case, you're interpreting the Nunavut Agreement, which is law in Nunavut. It's been incorporated into a statute, but every time you see something like Parliament, in this case, we're talking about the agreement. So really, we're talking about what was the intention of the drafters when they were writing the agreement. What did they intend? The exact same rules apply, though, so don't worry about that. It's the exact same. Next slide. I think the concept of same word, same meaning is pretty self-evident, where one word is used in one place and then the same word is used somewhere else, just means the same thing. Seems simple enough. So for example, and we'll talk about this more in the Nunavut Agreement, every time you see the word territorial means the same thing. Every time you see the word local, it means the same thing. Simple enough. But I think that the concept of different words, different meaning is a little bit trickier. So I want to give you a quick example. And we have this on the slide here. This is from a case called John Doe in the Government of Ontario. This is a Supreme Court of Canada case. So the top court's case. The question before the court in this case, they had to interpret, when I should say, I don't need you to turn to it. You have everything you need on the slide. But if you want to read it later, it's at the Book of Authorities, tab 19, QIA and BIMC's Book of Authorities. And as you'll see, it's also addressed in our written submissions at paragraph 73. So in this case, the court had to interpret a provision from a piece of privacy legislation, like an access to information type legislation. And the provision in that question, the words were, quote, "A head may refuse to disclose a record where the disclosure would reveal advice or recommendations." And what matters here is so someone can refuse to disclose if there's advice or recommendations. It's the phrase that matters for this example. And then the question the court had to decide was whether certain documents fell into that exemption. The initial decision maker in this case, so the equivalent of what would be the Territorial Board of Revision, like the first level administrative decision maker, decided, decided to disclose the documents, and then the case was appealed and went all the way to the Supreme Court. And the big question for the court was, what does it mean for something to be advice or recommendations? What did that phrase mean in the statute? And then that takes us to this excerpt. And the court actually found that the initial decision maker's decision, one of the reasons it was not reasonable, the problem with the decision, is that she basically gave those words the same meaning, but they had to have different ones because they were both there. So now we'll go to read paragraph 24. It appears to me that the approach taken in this other case and by the adjudicator, so that was the first decision, left no room for advice to have a distinct meaning from recommendation. Next sentence, advice must have a distinct meaning. I agree with this other case that in exempting advice or recommendations from disclosure, the legislative intention must be that the term advice has a broader meaning than the term recommendations. Otherwise, it would be redundant. By leaving no room for advice to have a distinct meaning from recommendation, the adjudicator's decision was unreasonable. So the only reason I show you this case is to give you this example that because the words advice and recommendation were in the same provision, the court said, well, they have to mean something different, otherwise they wouldn't both be there. And that exact same presumption applies to you in your interpretation. Next slide. So that's ordinary meaning. You look at the natural meaning of the words. You can look at a dictionary if you want. When you're reading it, you have to remember that the same words have the same meaning. Different words have different meaning, and every word has a meaning. So you have to read it in a way that means nothing is left out. Then we get to the second step, which is context or scheme. In interpreting a provision in context, decision makers are required to consider how everything fits together. That first step we talked about, grammatical and ordinary meaning, is crucial, it's essential, but it's not enough on its own. You also have to look at how a provision fits into the broader scheme that it's within. And you'll see the way this is, again, from Professor Sullivan, but she's quoting a case, and this is the sort of statement of what you're looking at. The broad general rule for the construction of statutes is that a section or enactment must be construed as a whole, each portion throwing light, if need be, on the rest. And then going down to the bottom highlighted section, when words are read in their immediate context, and that's the grammatical and ordinary meaning, so your first reading, the reader forms an initial impression of their meaning, which is more or less clear and precise. The modern principle, and that just means statutory interpretation, requires this initial impression to be tested against the inferences that may be drawn from considering other provisions of the Act, its components, and its overall scheme. Which again means you take the provision that you're considering, you read it in the context of, we'll talk about what you read it in the broader Act as a whole, and you think, well, what interpretation what interpretation is consistent with this whole thing? The intention, well, why does context matter? Why are you doing this exercise? It's because there is this presumption that the people writing laws, or in this case, writing an agreement, have made, and this is, I'm pulling the quote from this as well, an interconnected, harmonious web of provisions. The idea is that it's drafted to make a complete whole that works together perfectly, and that when you're considering an interpretation, you have to think about, well, given that they were trying to create this whole complete scheme, what interpretation makes the whole scheme work together? Next slide. We already talked about a few different presumptions that applied at the ordinary meaning stage. They apply all the way through. They apply at every step of the statutory interpretation approach. And in fact, in some ways, they're even more important at this stage, because this is where you can look at how words are used throughout an act and consider, well, how do I make sure the same words have the same meaning and different words have a different meaning? So we see here, Professor Sullivan says, it's presumed that the legislature uses language carefully and consistently, so that within a statute or other legislative instrument, and in this case, we have the Nunavut Agreement, same words have the same meaning, different words have different meanings. Once a particular way of expressing a meaning has been adopted, it is used each time that meaning is intended. Given this practice, it follows that where a different form of expression is used, a different meaning is intended. And I will give you another example of that in a moment. But first, I want to take you, give you a little bit of insight into what sources you can consider in thinking about context. Next slide. So what are permissible sources? What are you allowed to and supposed to look at in considering what context means? Well, the first thing you do is reading each provision together. And in this case, it'll be Article 22, which, as you heard from my colleague, actually has a lot of different provisions inside it. So you think about, how do you read the whole thing together as a harmonious whole? You read the act together, which in this case means reading the entirety of the Nunavut Agreement together. Don't worry, we won't go through the entire agreement today. We certainly don't have time to do that, but I'll take you later today to the key parts that you need to read together to consider context. And you're also permitted to read similar statutes from the same level of government together, which we'll talk about with the Nunavut Agreement. The Nunavut Agreement is actually federal, so it's the highest level of statute. It's even quasi-constitutional. It has the very kind of highest designation. And PATA is not the same thing, but there is a way that they connect, and we'll talk about that next. Next slide. So you can look, how does PATA and the Nunavut Agreement work together? Usually, statutes from different levels of government are not read together. So in this case, you wouldn't use them together because PATA is a piece of territorial legislation. It's passed by the government of Nunavut. The Nunavut Agreement was negotiated with the federal government. It's a higher level and it's a constitutional document. So they normally wouldn't go together. But the Nunavut Court of Justice, so the court here, has confirmed that Nunavut legislation, so territorial legislation, can be read with reference to paramount federal legislation, which is the Nunavut Agreement. And that particular case was considering the Wildlife Act, so it's a different act, but the point is totally applicable here, which is to say, well, you can read territorial legislation, or you can use the Nunavut Agreement to inform territorial legislation, but not vice versa. So that's a one-way thing. Nunavut Agreement informs PATA, but PATA doesn't inform Nunavut Agreement. So those are the sources you can look at. Most important source really is the Nunavut Agreement and the provisions in it, making sure everything can be read together as a harmonious whole. There's next slide. One source I want to take you to you can't look at, We already talked about the lease a little bit, but one point I want to make very clear is that the lease is not permissible context in the sense that you don't need to worry about, oh, is the lease consistent with Article 22? That's totally irrelevant. A lease made by different parties, like two parties, a commercial lease made by parties 20 years after a law is passed or an agreement is executed, in this case, the Nunavut Agreement, is not permissible context. It does not and cannot help you determine what the drafters intended in crafting Article 22. So that is not, the context you can look at isn't part of the lease, because there was never an intention that the lease would form a part of this harmonious whole. So that's out. Next slide. So I wanted to give you another example of different words, different meaning in the context step, because we already talked about, we talked about that example in the ordinary meaning step, where there was a piece of legislation that said advice and recommendation. Okay, those words have to mean something different, but what happens? How does that presumption apply for context? So this slide again is from Professor Sullivan. She here is discussing a case where the Supreme Court of Canada had to interpret a provision from the criminal code that dealt with insanity. The section in issue said that a person is insane only if he or she is incapable of appreciating the nature and quality, there's a whole long provision about what matters for you, incapable of appreciating the nature or quality of the act or omission, or this is what matters, or of knowing that it was wrong. And the question before the court was, what does it mean to know that an act is wrong? Something that's important is that which isn't from this section, the word unlawful, there was the word unlawful in other places in the criminal code, there still is, and unlawful meant illegality. So we see here in Schwartz, Chief Justice Dixon argued that the word wrong must mean morally wrong and not illegal, because elsewhere in the code, the term unlawful is used to express the idea of illegality. By using the word wrong, the legislature must have meant to express a different idea. So, just to sort of say that another way, because I know it's a bit complicated, the phrase in question here, knowing that it was wrong, what does it mean? Well, what really mattered is the court applied the presumption of different words, different meaning that we talked about, and it found that wrong couldn't mean illegal, because in other places in the code, the way something, the word unlawful meant illegal. So if the legislature here was trying to say that something was illegal, they would use the word unlawful, and because they didn't, wrong meant something else. And then they said, okay, what does it mean? It means morally wrong. So it's the same thing. Because it was a different word, it had to have a different meaning. But in this case, it wasn't in the same provision. It was in a totally different place in the criminal code. The criminal code, like the Nunavut Agreement, a really, really big statute, but still, every time a word is in there, it means the same thing. Because wrong was the word used here, it couldn't mean illegal. So I hope that provides at least a little bit of insight for you into how different word, different meaning operates in practice at the context step. Next slide. So we have gone through 2 of the 3 steps now. We've talked about ordinary meaning, which is where you make sure each word has a distinct meaning. You make sure words have the same meaning every time, and different words have different meanings. Next, you look at the context of the words. You read them in light of the whole scheme in question, and you consider how they fit into that scheme so that everything can be read together harmoniously. The final step is considering the object or purpose of a scheme or act. Again, we're still in paragraph 73 of our submissions. This is, again, like I said, it's a long paragraph, 73C. And the question really is a pretty simple one. What is the act intended to achieve? What is its overall goal? How does the provision fit into that goal? How does the provision facilitate that goal? The idea being your interpretation, the interpretation that is adopted should be one that facilitates rather than frustrates that scheme or that goal or that purpose, whatever it happens to be. Where do you get purpose from? Sometimes it says it comes out and says it in the act or legislation in question. And in fact, with the Nunavut Agreement, it does so, that we know what the purpose is because it says so. The other thing you can look at is the legislative or negotiating history. So the history that brought that document into force, you can look at that to consider, well, what were they trying to do here when they passed this? What was the goal? Like, why does it exist, basically? Next slide. So we've actually gone through the three main steps now, which are ordinary meaning, context, and purpose. Those are the three big ones that you do. But there is this final step, and that's the one that this slide addresses. That's also helpful in interpreting a statute. This one is addressed at paragraph 74 of our submissions. And it involves consideration of the consequences of adopting a particular interpretation. This is a very practical step. In considering this, you think, well, what does this mean in practice? Like on the ground, what would this interpretation do, and does that make sense? There's another presumption, the last presumption I'll tell you about, I'm sure you'll be happy to hear, that is quite relevant at this stage, and that's the presumption against absurd results. So again, a kind of formal way of saying something that really is quite simple. There is this presumption that the legislature doesn't intend for absurd things to happen. And where an interpretation creates an absurd result, it's probably not the right one. And we see a quote here again from this case Rizzo, which is the big one. It's a well-established principle of statutory interpretation that the legislature does not intend to produce absurd consequences. An interpretation can be considered absurd if it leads to ridiculous or frivolous consequences, if it is extremely unreasonable or inequitable, if it is illogical or incoherent, or if it is incompatible with other provisions or with the object of the legislative enactment. So this is kind of a common sense check where an interpretation would lead to something that's like totally crazy and makes no sense, then it's probably not the right interpretation. And that's all that presumption means. So that's the end of the statutory interpretation section. Those are the key principles that you need to keep in mind from a statutory interpretation perspective in interpreting Article 22. And again, if you need more guidance on that or sort of have forgotten some of the stuff we've discussed today, this is all in paragraph 73 and 74 of QIA submissions. However, there are a few additional rules that change the situation here a bit because the Nunavut Agreement is a modern treaty and there's specific rules attached to interpretation of modern treaties. And my colleague will take you through those now.
Chair, I might amend what I earlier said. This might be the right time for a break if you wanted to take a morning break with some time in between then for submissions before lunch. I just worry if we continue here, the break is going to come very close to lunch.
Okay, I think that would be good. So let's take a 10-minute break, and we can all come. Don't log out. Just blank your screen if you choose, and we'll all come back on in 10 minutes. Thank you very much.
Thank you.
Okay, I think our allotted break time is up and we can continue. Jeff, thank you very much.
Great, thank you, Chair. Just taking a little bit, taking a quick look at just sort of our pacing and timing here. I think we're moving a little bit quicker than we thought we might. So we've got a couple more sections to discuss in relation to what are the tools as to how you interpret the Nunavut Agreement and how you interpret provisions that we're going to put in front of you. It may be in my submissions I come to a point a little bit earlier than the intended time for the lunch break that you had suggested, but I'll point that out to you and you can decide if that's the appropriate time.
Yeah, thank you very much, Jeff. Please proceed.
So my colleague, Ms. Laskin, has just discussed with you the law that generally applies when you are interpreting any sort of provision in an agreement and legislation. But here we're dealing with a very particular kind of agreement. There's a very particular set of principles that apply when a court, when a tribunal like yours is interpreting a modern treaty agreement. In our written submission, we set out these principles at paragraphs 71 to 87. And I want to spend some time on these principles with you. QIA, as a beneficiary of this treaty, is of course highly invested in how this agreement is interpreted. And as I've mentioned, courts have had the opportunity over the course of a number of modern treaties being entered into in Canada, primarily in Northern Canada, Yukon, NWT, to some extent here in Nunavut. They've had the chance to interpret provisions and they've had a chance to observe the rule or to set the rules for how that interpretation is to take place. Happily, in my suggestion, you'll see there's no conflict between the statutory interpretation principles that you've just heard about and modern treaty interpretation principles. Instead, the main takeaway that I suggest you'll take from the cases that I will show you is that if anything, what these cases tell us is that a tribunal must strive to respect the text that the negotiators chose, to pay very close attention to the wording of the provisions that were agreed upon. As the courts have observed, and I'll take you to some of these in a moment, these sorts of agreements are quite different than, say, other commercial contracts that are negotiated between parties. They're meant to deal with a very vexing reality. And that reality is a general lack of recognition of Indigenous rights and Inuit rights in this circumstance, and a monumental effort by parties to these treaties to set a new relationship as between the Indigenous signatories and the Crown. You'll see from the how long it took to negotiate this treaty, the length and complexity of this treaty, that it was incredibly important to all parties to really reset that relationship and provide a new set of obligations for the treaty partners to follow. The treaty that's in front of you was the negotiators' best attempt to set a new foundation for reconciliation within this region. And I'll say this as well, the text of this treaty is to last forever. It's indefinite. This isn't a commercial treaty or contract between parties that will just eventually come to a close. This agreement is going to last forever or until it's amended. Over the 20-some years that this agreement has really been functional, there's only been one amendment to this treaty, It is a very difficult thing to amend these treaties, and the parties spent a lot of time to try to get this right the first go around. So we say the tribunal and any decision maker that's looking at these treaties should not deviate lightly from the words chosen by the negotiators. The different principles that arise for the interpretation of modern treaties arise from a couple of observations that the courts have made. Unlike historic treaties, so historic treaties are, for example, the treaties that were entered into in the prairie provinces, in parts of Ontario. Those historic treaties were generally negotiated over the course of weeks, if not days, and sometimes hours. They were primarily written by the Crown parties, and they are all very brief. The treaties that govern large parts of southern Canada are only a matter of pages long. The Nunavut Agreement, by contrast, was meticulously negotiated over literally decades by armies of negotiators, armies of government lawyers, armies of lawyers, frankly, for Inuit parties. The parties were well resourced when they were negotiating this agreement. As I've mentioned, these were intended, and sorry, I'm giving you quotes here. These are quotes that are drawn from the case law that's cited at paragraph 77 to 87 of our submission. The purpose of these treaties was that they were intended to foster positive, mutually respectful, long-term relationship between the signatories. Both of these facts have led the courts to reiterate time and again that decision makers must be very careful in interpreting these treaties, because the interpretation of these documents, as here, will have long-term implications for the relationship between Indigenous peoples here, Inuit, and the Crown. The rules that you set here, and sorry to place, it is a heavy burden that all parties are placing on this tribunal. The interpretation you make of this agreement is going to apply to all Inuit lands throughout Nunavut, as long as this agreement exists. So that calls for extreme care to be paid. What's been observed is that what this requires, the key principle, is deep attention to the text as the primary means of interpreting these agreements so that they can achieve their purpose. So I want to spend some time talking about the case law that goes into informing this principle. Now, again, my colleague, Ms. Laskin, has really pointed you in quite a detailed way to what are the principles that you have to follow when looking at the language of this provision. Here, we're going to say this over and over again, but the parties meticulously negotiated, in particular, the definition of real property taxation. They meticulously negotiated the terms that would govern Inuit-owned lands. They negotiated a very different tax regime to apply to those lands than apply to other private lands. And as I've shown you, the legislature of Nunavut has not implemented that tax regime in legislation. So we have to look at the words of the treaty, pay close attention to the choices of the parties when they were crafting the language that went into these treaty provisions. So when evaluating competing interpretations, we have to keep these principles in mind. Whose interpretation, QIA's or Nunavut's, or the government of Nunavut's, whose interpretation pays deference to the text of the treaty? By deference, I mean pays respect to the words that they used. Really strives, as my colleague just mentioned, to give meaning to every word that is in these provisions. This exercise, I apologize for it. I said earlier I wouldn't apologize anymore. I do apologize for it. The exercise is exacting. And I'm going to, in a moment, in the next section of our argument, walk through in detail every word, what every word does to the next word, what all of these words together mean in a provision, what the provision then means given other wording within the agreement. And the reason for that is that the courts have been clear. We have to pay deference to the text. We have to pay close attention to the terms that they arrived at. And ultimately, what the court has said is that the court and the tribunals in the same shoes should strive to respect the handiwork of the parties. So the overarching question here is, which party in front of you today is given meaning to the text of that treaty? Our submission, which I'll give you a preview of, is that the government of Nunavut urges this tribunal to adopt an interpretation that I say doesn't respect the language chosen by the negotiating parties. We say that the government of Nunavut instead seeks to substitute language to fail to give certain words in the definition of real property taxation real meaning. They do this because it's convenient for government to adopt the interpretation that they put forward. It allows them to apply a broad taxation in an area where it's supposed to be narrow taxation, and it allows them to put the funds collected through taxation to broad territorial purposes, rather than for the local government services and improvements that were agreed upon in the treaty's language. Now, by its express terms, the parties have agreed that this agreement is to be construed and to be interpreted very strictly. I mentioned historic treaties a moment ago. When courts are looking at historic treaties, treaties that were primarily negotiated about 120, 130 years ago or longer, the courts there have said, well, these treaties were kind of negotiated in a very one-sided way. They're very briefly negotiated. Indigenous groups didn't have armies of lawyers. They weren't well resourced. And in fact, the Crown typically had oral negotiations and then they wrote the treaty. What the court there has said is, where there's ambiguity in the historic treaties, you should resolve it in favor of the Indigenous parties. Here, in the case of a modern treaty, and specifically in the case of the Nunavut Agreement, that's not the case. The Nunavut Agreement, section 2.9.3, which is what I've quoted from here, is express about this. We're not to give the benefit of the doubt to any one party. There shall not be any presumption that doubtful expressions in the agreement be resolved in favor of government or Inuit. We're on a level playing field. We say this is critical in this case. We're going to argue that the government of Nunavut asks, in essence, for this tribunal to ignore the words chosen by the parties, ignore very specific words. In particular, really diminish the meaning of the word local in that definition of real property taxation that I showed you. And instead, it asks that we simply allow it to apply its outdated legislation. Our overarching point is that this task requires much more discipline if the treaty is going to lead to reconciliation. It was those negotiators working over decades, establishing relationships, identifying mutual interests, and really hashing out very difficult problems, hashing out very real differences. For instance, the difference that I advised you of earlier, which is at the outset of negotiations, the Crown wanted very broad taxation power for all Inuit-owned lands. Inuit wanted no taxation, similar to what their Inuvialuit cousins received in their land claim agreement. Ultimately, they hashed out something else. And it was not simply to say the territorial taxation law applies. It was arriving at a brand new article that is detailed, a brand new definition of real property taxation that could then be applied. And it's only that that could be applied because there was a broad exemption of any other kind of taxation being applied against those land. So I'm going to be exacting about it, and so should you. Those parties had an idea of what would lead to long-term reconciliation, what would the appropriate legal basis be to lead to that reconciliation. And really, as the courts have observed, the goal of these treaties is to bring Inuit rights into the mainstream of Canadian law. We're not having to apply special rules of interpretation or talk about what is the real true intent of the treaty. The intent is spelled out in the words. And so we're going to spend time with the words, and we're going to try to defer to those words. The last item of modern treaty interpretation I'll bring you to is what happens if a modern treaty is inconsistent with territorial legislation. The treaty here is clear on this as well. My colleague, Ms. Laskin, this afternoon will be speaking in greater detail about this. But the last principle here is that the Nunavut Agreement prevails over territorial legislation that is inconsistent with it. You've seen this from our written argument. This arises both from the article of the treaty, and that's the article I've quoted on this slide. There's also, I think as my colleague Ms. Laskin mentioned earlier today, there is federal law that adopts this treaty and that reiterates that the text of the treaty prevails over territorial legislation. So next we're going to move to our submissions on what we say is the proper interpretation of Article 22. Just as a review, there's three critical features of Article 22 that inform our overall interpretation. First, I've shown you that there is a broad tax exemption. There can be no tax paid by Inuit for Inuit lands unless that tax is set out in Article 22. That article sets out that real property tax, something called real property tax, can be imposed. But real property tax is different than property taxation as defined in the territorial legislation. Real property tax in Article 22 is defined as a tax imposed for local government services or improvements. And there's some other words that I'll show you in a moment. This appeal turns on the interpretation of that term, as we've said. Here's our interpretation. Real property taxation may only be imposed on Inuit lands if local government services or improvements are provided locally. If there is a connection between the local government services or improvements and the lands themselves. Here's the steps we're going to sort of go through to show you why our interpretation it should be the one that's adopted by this tribunal. First, I'm going to take you through an exercise where we closely examine the ordinary meaning of this defined term. Second, I want to ensure that we defer to the text. We're going to strive to give meaning to all of the words chosen by these treaty partners. Third, my colleague Ms. Laskin is going to examine the broader context that she spoke about, is going to look outside of Article 22 and to other provisions of the agreement to test whether our interpretation is consistent with that context. And at the same time, to test whether the government of Nunavut's interpretation is consistent with that broader context. Finally, we're going to look at some of the negotiating history, the context in which this treaty was negotiated, and look at some of the purposes of the agreement. Again, to test whose interpretation is consistent with that broader context, whose interpretation fulfills or otherwise undermines the purposes of the agreement. So we'll start first with this ordinary meaning exercise. In our written submissions, we start this exercise at paragraph 98. And as I go through this next section here, what I've done is inserted the key language into the little gray box on each slide here, and trying to show you where I'm trying to focus. So first, we start with the word local. The task of the tribunal is to understand, what does that word local mean? We're going to go stepwise through each. The word local, I guess before we do that, I might say some words I haven't actually done a specific slide on. I want to talk about the words imposed for, at the risk of making this a bit more exacting. What we say is those words imposed for, the ordinary meaning is clear. They denote an intention to set out a justification for a tax. This is a tax that is imposed for particular things. This tax is collected from lands, is imposed on lands for particular purposes. What are those purposes? The first marker is that those purposes are local. This is the word that they used in this definition. This definition applies both to the municipal taxing authority when they are assessing taxes, or when they are assessing a property and imposing taxes on that property. It also applies to the territorial government. So the first marker here is that they're local. What we've done in our written submission and what I've replicated here is dictionary definition of local. It's not the be all end all, but I use it to inform. It seems funny here to be sitting here trying to say, well, what does local mean? I think everybody here has an ordinary understanding of what the word local means. Local for us, we say this is the ordinary meaning, means a particular place. It's primarily serving the needs of a particularly limited district. This is the dictionary definition, and it's in our Joint Book of Authorities. Of, relating to, or characteristic of a particular place, not general or widespread. Everybody knows that's what local means. We say for our definition, this is a particular import. Local means a particular place, doesn't mean the whole territory. Next, with that limited spatial scope around the word local, we say that modifies the meaning of the word government. This is a tax imposed for local government services or improvements. This is not any level of government. It's specifically local government services or improvements. So what is local government? And this is one of the key points of difference between our interpretation and the government of Nunavut's interpretation. We could look to dictionary definitions. I'll say I find these somewhat less helpful, but we start to go in a certain direction. You'll find in your various authorities that are before you some competing definitions. At tabs 58, 59, 61, there are a number of dictionary definitions. What these definitions point towards is local government is municipal government. It denotes a level of government with authority limited to a particular area. It is distinct from larger forms of government. In Canada, those are typically the territorial governments, the provincial governments, the federal governments. Local governments have a particularly circumscribed set of authorities, and it's circumscribed spatially to a small area. That's the ordinary meaning of local government from our perspective. Importantly, and this is a point this is where we depart from the territorial government's interpretation of this section. We say this is wholly distinct from territorial government. The government of Nunavut, in their submissions, they suggest that because there's areas in Nunavut where there are no municipalities, that the territorial government is the de facto local government. That they are both a territorial government and they are a local government, and there's no distinction between the two. Now, in this sense, I don't doubt they do wear multiple hats, but it can't be said that the broad functions and services of a territorial government are captured by the ordinary meaning of the phrase local government. Further, this disregards the fact that territorial government is given a different meaning within this very same agreement. and this will be dealt with by my colleague, Ms. Laskin, likely this afternoon. Remember, the same words have the same meaning. Different words have different meaning. The negotiators chose the phrase local government. They could have just chosen government. They could have chosen any other number of words. They chose this word, local government. I say the ordinary meaning of that is entirely plain, and I won't spend much more time on that on this slide. Next, services and improvements. We say the words services and improvements are modified, that their meaning changes when read next to local government services or improvements. We say the ordinary meaning of this phrase is that the negotiators were not intending to discuss any sort of government services. Instead, they're pointing to a particular set of government services or improvements. It's those government services and improvements that are provided by local government. Those are local services and improvements. This denotes a particular class of services and improvements that are limited spatially. Now, again, we differ with the government of Nunavut on this. The government of Nunavut's submission is that because they are the de facto local government, that the services and improvements that they offer, whether or not they're spatially located near this property, are local government services and improvements. I do not think that is the ordinary meaning of local government services and improvements. What we suggest is that the government of Nunavut's interpretation is, with respect, an affront to the language that were chosen by the negotiators. I'm not asking you to put yourself in the shoes of the negotiators that were drafting this treaty, but I don't think it's a stretch to say, I think they would have found that interpretation very curious. That if the intention was to allow for taxation for remote Inuit lands, and that the justification for that taxation was going to be that there was a territorial government pension that needed to be paid, I think that the negotiators might have chosen very different language if the intention was, yes, you can raise tax for that purpose. The tax here is limited to a very specific purpose, local government services or improvements. Next, you'll remember that the definition of real property taxation is a tax imposed for local government services or improvements, including for schools or water. What we say is that if there is any doubt that the negotiators were conceiving of the local government as the territorial government, that's removed by the types of examples they chose to illustrate what local government services or improvements would be. The words chosen by the sophisticated negotiators for this treaty were quintessential local government services, services with a close connection to a local area, and that would benefit Inuit lands. It's these types of services that justify the imposition of taxes. They're imposed for these sorts of purposes. You'll read in the government of Nunavut's submissions that there is no restriction on what they can spend the taxes that are collected from these Inuit-owned lands are. That the funds that are to be collected from the taxation of these remote lands will arrive in the government of Nunavut's general revenue account and can be put to any number of purposes. What I say is that to adopt that interpretation it amounts to having to believe that the words schools and water in this section could easily be replaced with a whole host of other territorial expenditures. Could you easily replace the words schools and water here with, for instance, administration of justice, payment of legislators' salaries, construction of government buildings in Iqaluit, all territorial functions? Those are not the illustrations that the negotiators chose to include in this section. I think, again, that's an affront to the plain language and ordinary meaning of the phrase local government services or improvements, including for schools and water. This is language that is clearly intended to narrowly define the kinds of local government services or improvements for which a tax could be imposed for. Had the negotiators intended to provide a much wider ambit, I suggest there's all sorts of words that they could have used, all sorts of examples that they could have chosen. Instead, they've chosen quintessential local government services. Government services, government improvements with a close connection to the immediate area. So to summarize, and again, this is the first step in looking at statutory interpretation, but I think it should be a highly influential one in your thinking. As I said earlier, the words mean what they say. On reading these terms, what's your first impression? Is your first impression that the negotiators chose the words local government with the intention of including the territorial government in that? Is your first impression that the word local government services or improvements are those services that are typically offered by quintessential local governments, municipalities? Or is your interpretation that, well, these words, they were likely meant to also include all sorts of territorial functions, providing government services and improvements in areas far removed from Inuit lands with no connection to Inuit lands? Is that your first impression? I suggest it can't be. It's clear from these words that the negotiators, in arriving at a hard-fought compromise between their positions, were denoting specific local services and improvements that could be delivered in relation to the lands to be taxed. There's a fairness in that. The government of Nunavut's interpretation, I say, doesn't read these words closely, doesn't defer to the text as the court has ultimately required decision makers to do when you're interpreting a modern treaty. Instead, they attempt to conflate local government with territorial government. We are, the words of their written argument are, well, we are the local government because there isn't a municipality here. In fact, in this area, for these particular lands at Mary River, there really is no local government. There is no services or improvements that are delivered. Any improvements or services offered at the lands or in relation to the lands or even remotely near the lands are undertaken by Baffinland. There is no government in this area. To adopt the government of Nunavut's submission is tantamount, I say, to suggesting that local government services need not be local at all. That can't be the ordinary meaning of these words. And more to the point, I don't think it's, with respect to my friends from the government of Nunavut, I don't think it's a serious attempt to look hard at these words. You'll see from the government of Nunavut's submission, they start and end their submission with somewhat of an accusation that QIA is bringing this appeal to let Baffinland benefit, to allow resources that should be in the government's coffers to remain in an international mining company's coffers. That sort of commentary I don't think is befitting the exercise that's before us. which is to arrive at an interpretation of this agreement that is going to apply to all Inuit lands throughout Nunavut forever. So our interpretation that we say gives meaning to each word, gives the ordinary meaning to each word, that defers to the text arrived at by the negotiators, is that Article 22 allows for limited taxation of Inuit lands. Taxes can be imposed on improved Inuit lands, provided that there are services or improvements provided in the vicinity of the lands to be taxed. We would not be here if there was any sort of government service or improvements, even within the larger vicinity of these lands. The record that you have before you, the evidence that the parties have filed, the evidence that the government of Nunavut has filed is clear. There is no government services provided anywhere in the vicinity of these lands. I say it's a fairly low threshold for the government to cross, but it's not been crossed here. And we'll get later to the implications of that. But on an ordinary, trying to determine what the ordinary meaning of these words are, I say again, the words mean what they say. Local government services or improvements, including for schools of water, necessarily means services located in the vicinity of the lands to be taxed. So I'll leave ordinary meaning there for now. Chair, just looking at the time, I know this is about 30 minutes prior to your intended lunch break, but I think it might make sense to break here before we move into the next section.
Okay, thank you very much, Jeff. So I think we'll go with that suggestion. We'll take an hour lunch break. I have 11 o'clock local time here, so if we can meet back here in 1 hour. And I would ask you, when you come back, if you could just please turn on your video so that we can make sure that we've got everybody back online, and then you could move to turn your video off after that.
Will do. Thank you, Mr. Chair.
Okay, thank you very much. We'll talk to everybody in an hour. Thank you again, Jeff.
No boundaries between your skin and your foundation. Discover the new True Match Foundation by L'Oreal, a moisturizer in a foundation.
Listen to music personalized to you. YouTube Music Premium. Start a 1-month.
Yogo Canadian Harvest has 40% more yogurt than a
Hey, Mercedes, tell us a joke.
Fleece Vibes, only at Old Navy and oldnavy.ca.
I can read you like a mood ring. And now I'm in it. Open up your eyes, you're about to see a new thing. Open up your eyes, you're about to see a new thing. Pick it if you like it, everybody want a new thing.
How doers get more done.
Thank you all for your participation this morning. I'm finding the QA's presentation very well done and informative, and I think we're ready to continue. Jeff, if you wanted to, thank you.
Great, thank you, Chair. I've dialed the slide presentation back a little bit. I just want to sort of remind everybody where we're at. So we are in the section of our presentation where we are talking about what is QIA's interpretation of Article 22, and in particular, the definition of real property tax. What I've just finished setting out is why our interpretation is consistent with the ordinary meaning of the words imposed for local government services or improvements. And sort of embedded in that, I've been trying to indicate how do we make sure we give meaning to all the words that were chosen by these partners, by the treaty partners, when they were negotiating Article 22. Next, Ms. Laskin is going to lead you through a submission on the broader context, indicating how is our submission consistent with the broader context of the Nunavut Agreement. And then you'll hear from me again talking about how our interpretation is consistent with the negotiating history and the purposes of the Nunavut Agreement. And you'll hear me say how I don't think the government of Nunavut's broader interpretation is consistent with those items. So let me try and find the slide I was on, and I'll hand it over to Aria.
Hello again. So as Jeff mentioned, I'll pick up at the point of context. As we previously discussed, there are three main steps in the statutory interpretation exercise: ordinary meaning, and then context, and then purpose. So I'm catching you again on step 2. We're going to talk about 3 different levels of context, which are summarized on this slide, but I'll go through each of them, so don't worry too much. The first one is the context of Article 22. And I will talk to you about how QIA's interpretation of real property taxation is consistent with the rest of Article 22, and specifically with Article 22.2.6, which deals with agreements between DIOs and municipalities for local government services. Second, we'll look at the Nunavut Agreement's overall terms and how QIA's interpretation is consistent with the entirety of the Nunavut Agreement, which treats territorial and local governments differently. Finally, we'll talk about how QIA's interpretation is consistent with how the word local is used in PATA. And as I mentioned to you earlier, this one is a little bit trickier because the interpretation only goes one way. Because the Nunavut Agreement is a paramount or higher piece of legislation, the Nunavut Agreement can inform PATA, but not vice versa. But what that means for the purposes here is that when local means something in the Nunavut Agreement, means the same thing in PATA, or it should, and we'll talk about that when we get to this stage. Next slide. In contrast, GN's interpretation is not consistent with the context. As you heard from my colleague earlier today, the GN's interpretation functionally conflates local government and territorial government. GN basically says, well, look, in the general taxation area, we can we can collect taxes in the general taxation area, including from these lands, and those taxes go into the territorial coffers. They're used for territorial purposes, and that's fine. We're allowed to do that. And we say that that basically turns the phrase local government services and improvements into the phrase territorial purposes, which you can't do because that interpretation is inconsistent with the context of the Nunavut Agreement. And we're going to see that by returning to those presumptions that I spoke to you about earlier today. The idea that same words have the same meaning and different words have different meanings. We say that GN's interpretation ignores those presumptions, which shows that that interpretation really isn't the one that the drafters intended. Next slide. So we'll start first with Article 22, and how the context of that article supports QIA's interpretation. As we talked about, the presumption, same word, same meaning. That means that the word local government services has to mean the same thing in the entirety of Article 22. We talked about how it's in the definition of real property taxation initially in Article 22.2.1. It's also, local government services are also mentioned in Article 22.2.6, which provides that DIOs, so like QIA, can enter into agreements with municipalities to provide, quote, local government services to Inuit-owned lands. That type of, and this is, or I should say, this is a QIA's written submissions at starting at paragraph 109. That type of arrangement is pretty common in Southern Canada, where a municipality and an Indigenous group, typically a First Nation in Southern Canada, enter into what's called a servicing agreement. The First Nation pays the municipality to provide stuff like water, sewage, fire services, emergency services, that kind of thing on the reserve. And that's what this provision is saying. The provision is saying, well, look, if you want local government services on particular Inuit-owned lands, you can pay a municipality to provide them. So in Article 22.2.6, local government services means exactly what it sounds like. The types of services that local governments usually provide, like water or fire, and the types of services that are not found anywhere near the Mary River Inuit lands. And again, it's pretty clear what that means in the local government services means in the context of Article 22.2.6. It has to mean the same thing in Article 22.2.1, which means it has to mean the same thing in the definition of real property taxation. Next slide. So moving to the broader Nunavut agreement. And again, as I promised, we're not going to go through the entirety of it, which would be impossible, but I'll take you to some of the most important points for the context piece. Territorial government is actually a defined term in the Nunavut agreement. So again, we don't need to turn to it now, but you can look at it later if you want it, tab 46 of our Book of Authorities. There's pages of definitions. There are a lot of terms that are defined. And of course, once defined, it means that term, that's exactly what that term means in the entirety of the agreement. Territorial government is one of those terms. It is defined. Local government isn't. Territorial government means any successor government having jurisdiction over Nunavut. So it means the government of Nunavut. It's used more than 100 times in the agreement for all sorts of different reasons, for all sorts of different purposes, and we'll go to a couple. It is not used a single time. It is not used in the definition, I should say, of real property taxation. That definition could say that real property taxation is for territorial purposes, for territorial government purposes. It could have said that. The drafters could have said that. They didn't. They chose not to. There was a word that they could have used defined in the Nunavut agreement that would have created the interpretation that GN is urging you to adopt. The drafter said, no, we're not going that way. Instead, we're saying that the taxes may only be imposed for the purposes of local government services and improvements. So again, different words have different meaning. The fact that the drafters did not decide to use the word territorial government, territorial purposes in Article 22.2.1 is relevant. It's especially relevant, and you heard a bit of this from my colleague, because the parties do, the GN says, this is not contested, that taxes from the Mary River Inuit lands will go into general coffers. They go into general revenue. They're not earmarked for anything in particular. As I believe my colleague will also speak to later, we don't know exactly what that means, but we know that at least some of them are not going to anything you would ever consider to be a local government service anywhere in the territory. They're going to stuff like building buildings in Iqaluit, to territorial officials meeting with federal officials to talk about the implementation of the agreement. All important things, none of which are local government services, none of which, again, are mentioned in Article 22.2.1. And the fact that this term wasn't used has to mean something. We'll go to I'll just take you to one example of how territorial government is used in the Nunavut Agreement on the next slide. So again, I promised not to take you to the over 100 times that territorial government is used. I will take you to this one. This is from Article 2.12.2. And we actually will come back to this article later today to talk about what happens when there's an inconsistency between the Nunavut Agreement and a territorial law, because as you're going to hear from us, there is an inconsistency here, unfortunately. But for now, I'm only taking you to this provision to look at the actual text, to look at what it says. It says where there's any inconsistency or conflict between any federal, territorial, and local government laws and the agreement, Nunavut agreement prevails. And the same phrase, federal, territorial, and local governments, comes up again in Article 2.12.1. The reason that I'm highlighting this particular article is because I think it's a very helpful example of that presumption we talked about. Different words have different meaning. We see a mention of territorial government. We see a mention of local government. Because they're both included, they can't mean the same thing. So territorial can't mean local. It can never mean local. The presence of both of those words in the agreement means that that cannot be the case. But that's what GN is urging you to do. In contrast, the presence of these different terms is totally consistent with QIA's interpretation, because QIA says, well, local government services sounds like what it is. They're services provided in a local area, typically by like a municipality type local government, but they're services that have the character of local government services, and they're provided in the area around, in or around the lands in question. So local means the same thing here as it does there. Territorial is another thing. Territorial is the government of Nunavut, and that government provides a different function. Yeah, I think that's all I'll say there. A territory, I guess the point is territorial is not a synonym for local. Next slide, Jeff. Now we'll turn to PATA. And again, this particular piece of context only goes one way. PATA is not a lens for interpreting the Nunavut Agreement because it's subordinate legislation, but the Nunavut Agreement informs PATA. I think it's especially helpful in this case because, and you're going to hear more about this from my colleague, PATA was enforced when the Nunavut Agreement was being negotiated. So stuff like the words used in PATA would have been something the drafters were aware of. We've seen that the words territorial and local both occur in the Nunavut Agreement, and they occur to mean different things, distinct things. Territorial means Nunavut-wide. GN acts as the territorial government, discharges these territory-wide purposes. And local means close by or proximate, like how municipalities are local governments. They're the ones providing services in their local area. These precise meanings, the ones advanced by QIA, are reflected in PATA. Section 75, which deals with taxation in the general area, is for territorial, in the general taxation area, which is these lands, is for territorial purposes. Those taxes go to territorial purposes, which is consistent with the government of Nunavut's evidence that the taxes, if they were taxes here, they would go into the territorial general revenue, the big pot of money that is for all territorial purposes. In contrast, you can see section 76, which deals with municipal taxing, enables councils of municipal taxing authorities to tax for the purpose of raising a property tax for municipal or local purposes. And again, local there really does mirror the exact interpretation of local that we've been talking about, which is services provided in and around that area that have the character of local government services. Next slide. The take-home point for you with respect to PATA is that the meaning of the words territorial and local each means something different in the Nunavut Agreement, and we see those same meanings reflected in PATA. The QIA's meanings, what QIA is proposing. Territorial means territory-wide, local means something proximate, closer to home. So that concludes my remarks on context. By way of a very brief recap, before Mr. Langlois takes you through the final steps of the interpretation, where you'll look at the purpose and why the intention of the drafters would have been to create this scheme where real property tax is only imposed for local government services and improvements. Before you get to that, just by way of summary, we went through a contextual review of Article 22, the Nunavut Agreement and PATA, and the purpose of that review was to reaffirm that local government services means just that. Services provided by a government, typically but not always a municipality, to the local area. And I know that one of the things the government of Nunavut says is, well, in some places, we're the ones who are providing those services. You know, we're the ones who act like a local government in some places. That totally, we don't fully know the evidence on that, but to the extent that's true, then it may be that in some cases, the territorial government acts as a local government. But we're not talking about that case. We're talking about a situation where there is no local government. There are no local services. The only place that any taxes from there would go is the territorial coffers. And it's in that context, it's in this factual situation that we say that this contextual analysis shows that you can't ignore that local government services are supposed to be services provided to the proximate area where the lands are taxed, the Inuit lands in question. Any other interpretation renders Article 22.2.1, and specifically this magic phrase of local government services or improvements, including for schools and water, it renders it inconsistent with the rest of the Nunavut Agreement, which, as you heard from my colleague, was carefully drafted, carefully negotiated. All the words were intentionally included, and they should be given their meaning.
Thank you. So I'm picking up now at paragraph 124 of our written submission. In this section, we say that, you know, an additional area that you can look for to help you interpret this section is to consider the broader context that was in place while this provision was being drafted. What we say here is that the inclusion of a new definition of real property tax is significant because it differed from an existing definition of property taxation. If the intention of the parties was to simply follow the territorial government, was to allow the territorial government to impose taxation whether or not they deliver any local services to the lands that are at issue here, what we ask is, why did they go to the trouble of making a new definition? I think this is a highly pertinent question. We've asked the question in our written submissions, and we haven't heard an answer from the government of Nunavut on it. Let me explain this submission a little bit. I've previously discussed the terms of PATA with you. At the time that the Nunavut Agreement was being negotiated, there was territorial legislation that allowed property tax on essentially the same terms here. At that time, PATA was nearly identical, and it required the assessment and taxation of all lands and improvements with some exemptions. I'll bring up the language here again. Apologize, there seems to be, I think I've got a formatting problem with this slide here, but bear with me for a moment. As I said, this is essentially the same definition. So this is the PATA as it existed in the NWT. It defined property tax as tax payable under Part 3. The tax payable under Part 3 is Section 73, which I brought you to before. And so it had a definition of property tax in it. What we ask is, if the government of Nunavut's interpretation is to be accepted over our interpretation, we say the effect of that is to allow the government of Nunavut to simply apply PATA, to simply apply PATA's definition of property tax. It's simply tax that is collected by the government of Nunavut in the general area, or a municipal taxing authority in the municipal area and within the boundaries of the Iqaluit. But the negotiators had that option. They had the option of simply adopting the definition of property tax in PATA. They had the option of simply saying Inuit lands will be taxable pursuant to territorial laws of general application. They didn't do that. They instead negotiated a brand new article with a brand new definition of real property taxation with additional exemptions. So why did they do that? We say there's an unavoidable answer, and that is they intended to create a very different taxation regime. Recall again the debate that led to this article. The debate was on the government of Nunavut side, sorry, on the Crown side. It wasn't the government of Nunavut at the time. On the Crown side, the desire was, we'd like to tax all Inuit lands as if they were private lands. The desire on the Inuit side was, we don't want the lands taxed at all. What they arrived at was somewhere in the middle, where they created a new property tax regime that, in our view, requires that any taxes to be collected are to be imposed for local government services and improvements located in the area. I think this broader context is helpful to understand. They had the option to select the definition, the interpretation that the government of Nunavut puts forward here, and they didn't. They used very different words, and it's all of our jobs, and your job in particular today, to pay close attention to the words of the Nunavut Agreement. They chose that regime over the existing regime. I next have three somewhat reflective or higher level points to make. It's important when we're doing this sort of interpretive exercise. We've started at sort of the top level. What's the ordinary meaning of these words? How do we give meaning to all the words? Does an interpretation make sense in the broader context of the agreement and maybe other related statutes or agreements? ARIA's done that job. What we're looking at in this section is taking a step back. Test those interpretations that are in front of you and determine whether those competing interpretations, which one better furthers the various purposes that were set out under the Nunavut Agreement. So I've got sort of 3 points to make on purposes. The GN sort of has made a submission in their written submissions that the overall purpose of the Nunavut Agreement is to benefit Inuit. I think that's too broad of a purpose statement. I think the overall purpose of the Nunavut Agreement was to set that foundation for the reconciliation of Inuit rights and interests with Crown's assertion of governance powers in these areas. That's putting it very broadly. But there's a number of discrete purposes that underlie this agreement. I'm going to talk about a couple of these. The first, and I'm at about paragraph 131 of my submission. QA's interpretation is that taxation of Inuit-owned lands is limited to situations where Inuit-owned lands benefit from local government services. We say that's consistent with the quasi-governmental role of DIOs like QIA. I'll discuss that a little bit. While QIA holds title to Inuit lands, they are not the same as a private property owner. The same taxation regime doesn't apply to them, and I say it makes sense that it doesn't apply to them. QIA, as opposed to a private landowner somewhere else in Canada, is highly restricted in how it can manage its lands. It has to administer those lands in order to fulfill a variety of different purposes: community purposes, economic development purposes, cultural purposes. It is unable to sell those lands. It must manage those lands for present and future generations. It itself is a very different sort of landowner. In this light, it makes sense that there's a very different type of property tax regime that's created. One that would provide that there would be a land base that would be taxable to support local communities. So that is where there is Inuit-owned lands in the vicinity of communities where local government services are provided, it makes sense to draw upon a tax base that is partially comprised of Inuit-owned lands. That was a compromise that was made in the Nunavut Agreement. So this provides that where Inuit lands benefit from local government services, they pay for those like anybody else. But where Inuit lands do not benefit from such services, DIOs are not forced to pay those property taxes. It is different than some other landowners. Landowners that are only subject to taxation under PATA do not have the same recourse that QIA does. But that's fair in light of the very different nature of DIOs, in light of the very different nature of QIA's management of these lands. My friends from the government of Nunavut, they put forward at paragraph 53 of their written submission a case that's the Gander case from it's a Newfoundland Supreme Court case. They put that case forward to argue that there is, they assert there's a principle of law that there doesn't need to be a relationship between the amount of taxes paid and the services rendered by a government. So in that case, you had a private landowner complaining that he shouldn't be subject to property tax because he doesn't get any benefit from government services that are near his lands. Our response to that case is that it doesn't apply here. That is a case that is applying Newfoundland property tax legislation to a private landowner. That does not have an impact on the interpretation of a modern land claim agreement between Inuit and the Crown. We rely on the legal principle that is plain on the face of the Nunavut Agreement. The terms of the Nunavut Agreement create a very different tax regime than which you find under PATA. There are additional exemptions, though the government of Nunavut has not undertaken the work to incorporate those into territorial legislation. There are numerous exemptions to taxation of Inuit-owned lands that are just apparent and are not in dispute in this proceeding. We suggest that there is one additional exemption. That is lands that do not receive government services or improvements. Inuit-owned lands, that is, are not subject to taxation. Now, to be really clear, I'm not arguing, and QA is not here arguing, that there needs to be some sort of forensic accounting between the tax revenue that is derived from a piece of Inuit-owned land and the cost of local services within the area. I don't think the threshold is very high here, and there's nothing in the agreement that sets a particular threshold. We wouldn't be here in this appeal if there was any sort of government service or improvements that are made in relation to Inuit-owned lands, or that improves Inuit ability to increase their economic self-sufficiency on the basis of that land base. But I say there is a threshold that is built into that definition of real property tax. The tax can only be imposed for local government services. Here, there is no services provided locally whatsoever. So while I take Government of Nunavut's point that, well, why is QIA being treated differently? PATA says what it says. The answer to that in its entirety is that the Nunavut Agreement sets out a very different tax regime. It's the treaty partner's responsibility, and here it's been foisted on the tribunal to functionally deal with a dispute about that, but it's the treaty partner's responsibility to implement that section. And we say that's consistent with the overall purpose of the Nunavut Agreement in respect of QIA's role. Now, second, the government of Nunavut, their interpretation is that real property tax, or rather, the definition of real property tax, it adverts to local government. They say they are the local government. And indeed, under the Article 22, it's the territorial government that has the authority, or rather under PATA, it's the territorial government has the authority to collect taxes within the general taxation area. So not within municipal taxing authorities areas, but within the general taxation area. The question that arises is, why was the territory given a power to collect taxes if indeed the trigger for being able to use those taxes is the provision of local government services in relation to specific lands? It's a fair question. Our answer to that, though, is that the GN has been provided the authority to collect taxes in the general area because the context of Nunavut requires it. I won't take you to it, but Article 14 of the Nunavut Agreement recognizes numerous Inuit communities. It recognizes them as corporate municipal bodies. These are many of the communities that were contained on an earlier slide. Number of the hamlets and villages that are, proximate but not that close to the Mary River lands. There are within Nunavut a number of isolated, smaller population communities. But these municipal bodies, they do not have the ability to collect their own taxes. And I say that's for particularly good reason. It takes a lot of administrative capacity in order to assess lands, in order to impose taxation, in order to collect taxes, in order to execute if somebody falls behind on their taxes. Most of the communities in Nunavut, save for Iqaluit, are generally isolated and quite small. It makes sense in that context to allow the territorial government to be the tax collector and to provide those taxes to fund all sorts of local government activities. But simply because they're the tax collector does not mean that when they're wearing their the fact that they have a tax collector hat doesn't mean that everything they do is local government services or improvements. Our interpretation is that while limiting the territorial government's taxation power with respect to lands where it does not provide services, that our interpretation is consistent with the purposes behind the grant of the Property Taxation Authority to Nunavut. So my final point on purpose here relates to the purpose of Inuit-owned lands. We say that the overall purpose behind providing Inuit with their own lands is undermined by a taxation of those lands with no benefit to those Inuit lands. Our problem with GN's interpretation is that if it's allowed to tax all lands everywhere, regardless of whether services are provided to them, that this undermines the economic self-sufficiency purposes that are the defined purpose of Inuit-owned lands. Just to recall that purpose, the primary purpose of Inuit-owned lands shall be to provide Inuit with rights in land that promote economic self-sufficiency of the Inuit through time. Our concern here is whether or not this purpose is served through GN's interpretation. GN says it has the ability to impose property taxes on lands that are far removed from any government services. Under the government of Nunavut's interpretation, the Inuit, as they've done here, have selected sometimes remote lands far from communities, but that have economic potential, have potential for mining and other purposes. Under GN's interpretation, the Inuit took the risk of selecting those lands, have performed work in developing economic development opportunities with proponents. They fundamentally bear the risks associated with development. That includes, will this proponent take care of the land? Will this proponent clean up after themselves? Will this proponent be successful or not? Will we derive long-term economic benefit from these lands? These are risks that Inuit bear. GN's interpretation is that for Inuit lands that are far and away from any local government services, that Inuit can make those efforts, take those risks, and the government may collect taxes without ever doing anything in the area. They say that they're able to impose significant tax burden on these lands, use them for broad territorial purposes. I say this does not serve the purpose of Inuit lands. The GN wants to treat, in my view, IOL as a source of tax revenue without materially contributing to the economic self-sufficiency of Inuit in many of these areas. That to me is not the deal that was struck. The deal that was struck was that taxes could be collected from Inuit-owned lands where those taxes are imposed for local government services. That makes sense in the overall, to fulfill the overall purpose of these Inuit lands, which is to improve economic self-sufficiency for Inuit. So that brings us to the conclusion of our interpretation. We've taken you through the ordinary meaning of the words in the treaty. We've explained why our interpretation makes sense in the context of the overall agreement of related statutes. And it's our interpretation, not the government of Nunavut's, that's consistent with the negotiating history and the broader purposes. The next set of our submissions here deals with, so what? Now what happens? And Ms. Laskin will be taking on these last two sections, which are sort of one section in a sense, and will now be taking us through a submission as to why PATA is inconsistent with Article 22, should you be with us on the interpretation that we've put forward. And then what happens if PATA is inconsistent. So I'll pass it over to Ms. Laskin.
Thanks. Can we go to the next slide? So this morning and afternoon, we've discussed Article 22 of the Nunavut Agreement and how it creates an exemption from taxation for non-municipal Inuit lands unless certain conditions are met. And those conditions being, first of all, the land has to be improved and it's only specific improvements that render the land taxable. And second, any taxes imposed for those lands have to be used for local government services and improvements. They have to be imposed locally in or around the lands in question. And as Mr. Langlois mentioned, now we're going to turn to PATA and see what PATA says about these lands. As you heard from him earlier today, really the answer is it doesn't say anything. Even though it's been 20 years, PATA has never been amended to implement the Nunavut Agreement. Despite the fact that Article 22 puts together this very careful, intentional taxation scheme for Inuit lands, none of that is covered or mentioned in PATA. As a result, Inuit lands are treated like lands owned in fee simple by any entity besides the Crown, basically. I'm going to take you through exactly how that works in PATA what its implications are for Inuit lands, and why that's not consistent with Article 22. So we'll go to the next slide. So the first section of PATA I'll take you to is Section 5, which deals with whether or not property is liable for assessment. You'll see it says subject to Section 4, all of them, there's a list, land, improvements, units, pipelines, work, are liable to assessment. So it's pretty clear. Unless lands are subject to an exemption, so Section 4 sets out some exemptions, none of which deal with the Inuit lands. All of the property listed there, all the types of property must be assessed. And of course, that includes land, so that includes all Inuit lands. What's the bottom line? All Inuit lands have to be assessed, full stop. And then why does that matter? Jeff, we'll go to the next slide. Section 73 says, assessed property is liable to taxation unless it's exempt pursuant to particular sections. I'll tell you those sections again, no mention of Inuit lands, nothing like that. So again, we see there's no discretion, no leeway, no cutout for Inuit lands. All Inuit lands have to be assessed, and all assessed property, subject to exemptions that don't apply here, have to be taxed. And we go to the next slide. So the bottom line is that PATA requires taxation of all Inuit lands. The Nunavut Agreement, as we've discussed, forbids taxation in certain situations. And I want to be clear that this issue, although we're here today talking about what real property taxation means, what local government services and improvements means, this issue is actually broader than just what we're here talking about today, because of course the exemptions in Article 22 are much broader. We've talked about already briefly how Article 22 says, well, if the lands aren't improved, they can't be taxed. According to PATA, they have to be. And this is, to recall the phrase used by my colleague earlier, this is kind of what happens in the case of dinosaur legislation. It just was never amended. So it has this blanket provision saying, okay, all land is taxed, which would make sense, except for that Article 22 creates this carve out, and the legislation just wasn't updated to reflect that. So it's obviously not the most desirable state of affairs, but happily the Nunavut Agreement, as such a complete code, as such a carefully negotiated document, contemplates exactly what to do in this situation. So there is guidance for what happens in the event of this type of conflict. Next slide. And what happens is that the Nunavut Agreement prevails. And what does that mean? Well, we saw this article earlier when I was just taking you there for the purposes of looking at what territorial and local government means. But I'll read it for you again now that we're at this section where we're really looking at the meaning of this provision. It says, where there is any inconsistency or conflict between any federal, territorial, and local government laws and the agreement, the Nunavut Agreement, the agreement shall prevail to the extent of the conflict or inconsistency. Put simply, when there's a conflict between the agreement and a piece of territorial legislation, like PATA, Nunavut Agreement trumps. Next slide. What does conflict mean is probably, well, that might be a question you're thinking of, and it's certainly a reasonable question. Again, the Nunavut Agreement gives us guidance on how to interpret the term conflict. What does conflict mean? Article 2.12.4 says that for greater certainty, the term conflict shall be interpreted by having regard to the common law rules governing the interpretation of laws. And then to some other stuff that doesn't really help us here, but the common law rules. So the Nunavut Agreement says, when you're trying to figure out if there's a conflict, go look at the case law. That's how you'll figure it out. So that's what we're going to do next. Next slide. And again, happily for us, the law on conflicts and on paramountcy is very well defined and well developed. Paramountcy is just the term for this doctrine, where courts look at conflicts between federal and provincial statutes, where they say, well, is there a conflict? And then what do you do in the event of a conflict? And that law recognizes two different types of conflicts. So there's two types of conflicts that can arise. The first one is reasonably simple. It's operational conflict, which just means you can't comply with both laws. It's impossible. Dual compliance is impossible. So what would an example be? Well, it would be something like, you know, if the Nunavut Agreement says a particular type of building has to be 10 feet tall, and a piece of territorial legislation says, no, it has to be lower than 5 feet. Well, then dual, which obviously would be a very small building. So this is just an example. It doesn't say that anywhere. But that would be an example of dual compliance, where dual compliance is impossible. You have the Nunavut Agreement requiring building at least 10 feet. You have territorial legislation saying, no, it has to be smaller than 5 feet. Well, you can't comply with both. It's just not possible. The second branch is a little harder to identify sometimes. And that branch is the conflict of purpose, or frustration of purpose. What does that mean? It means that the operation of the subordinate law, so in this case, the territorial legislation, frustrates the purpose of the paramount law, in this case, the Nunavut Agreement. And this one arises where, well, even if, you know, you might be able to comply with both, there's a purpose in the federal enactment that gets frustrated by the subordinate one. And it's not on, I haven't written it out on this slide, but I've cited to the Canada Post case. You'll see that's at tab 5 of our Book of Authorities, which I think provides a helpful example. Canada Post, as some of you may recall a few years ago, said, okay, well, we're doing community mailboxes throughout the country. We can't deliver people. The amount of houses we're delivering to is too many. We are going to go broke, basically. We need to do community mailboxes. And people in Hamilton, Ontario were very unhappy about that. And the city passed a bunch of bylaws that made it really hard to put up community mailboxes anywhere. Like really, like functionally made it impossible for the community mailbox scheme to be implemented in Hamilton. And they said, well, dual compliance is possible. There's nothing in this bylaw that Canada Post can't, there's no laws that conflict. You can't show any laws that, you know, conflict. And the court said, that's true. But and I should say Canada Post is paramount legislation because it's federal legislation that lets Canada Post do stuff. The court said, well, we have this paramount scheme, the National Postal Scheme, and they can't do what they want to do, and they can't do what they're intended to be able to do, which is to govern postal services, because of these bylaws you've put in place that frustrate their ability to put down their community mailboxes. So there is an issue with paramountcy. There is a conflict because these bylaws frustrate the purpose of this federal scheme. So it was in that case held to be unconstitutional for the municipality to do that. So that's just one example of what a conflict of purpose can look like, where, yeah, in theory, you could comply with both, but it would really, you know, mess up. It would really frustrate the federal scheme, and you're not allowed to do that. We can go to the next slide. So what happens in the event of a conflict? Again, the case law is really clear and very tells you exactly what to do. And because the Nunavut Agreement tells you, go look at the case law, this is what happens. This is not a kind of controversial thing. Where there is a conflict, either an operational conflict or a conflict of purpose or both, the quote unquote paramount, the higher legislation prevails, and the subordinate or lower legislation is what's called inoperative to the extent of the conflict, which just means it doesn't apply. The legislation doesn't go away. It doesn't become unconstitutional in general, like nothing kind of major and dramatic happens. It just means that just for that area where there's a conflict, the legislation that creates the conflict doesn't apply. And we've given you an example. This is in our submissions at paragraphs 147 and 156. But the example we've written about in the submissions I've reproduced here, it's a Supreme Court case called Maloney. In that case, and that's again a Supreme Court, so high level case, an Alberta official relied on an Alberta statute, so provincial statute, to suspend an individual's driving license because they had unpaid debts arising from a car accident. But by that point, the individual had declared bankruptcy, which is dealt with on a federal level. And the bankruptcy law in question included a provision that's released him from all his debts. So he doesn't have debt. Under the federal statute, he's released from debts. And the individual said, well, you're not allowed to suspend, Alberta is not allowed to suspend my license because of the debts, because the federal statute says I don't have debts anymore. And the federal one is the one that applies. And the case went to the Supreme Court of Canada, and the court agreed with the individual. It held that the provincial provision in question did create this conflict. And as a result, it was inoperative to the extent of the conflict. So it said the province cannot withhold the respondent's driving privileges on the basis of this discharged judgment debt. So what does that actually mean? Well, the provision wasn't rendered generally unlawful. Anyone else with a debt still can't get a driver's license in Alberta, unless however the statute operates, that's still a basis for withholding a license. All it meant was that to the extent that this person had this had their debts discharged federally under a federal act, the province could no longer withhold the license because of that conflict between the statutes. The provision in question just did not operate in this case because of this federal conflict. And as we'll go through, the same outcome is required here. If you accept our QIA's interpretation of Article 22, then it's pretty clear there's a conflict. And as a result, PATA just won't apply in this particular type of situation. The Nunavut Agreement will apply on its own. But PATA keeps applying to everything else. The sky doesn't fall. It's just read in a way that makes it not apply in this situation to enable a constitutional outcome, a legitimate outcome. And I don't want you to think you're being asked to do something that's never happened before, because in addition to the fact that this happens in courts all across the country all the time, it's actually already happening here. And in Nunavut, and you've heard a little bit about this already. Article 22 does not permit taxation of unimproved Inuit lands, or of Inuit lands where the improvements are exempt from taxation, like outpost camps or traditional camps. Excuse me. The assessors already have to, and to our knowledge, do look at that, and they're actually that Inuit lands that aren't improved, they're not being taxed, but under PATA they have to be. Well, why aren't they? Because the assessors are already applying the Nunavut Agreement and saying, well, where there's a conflict, Nunavut Agreement prevails. We're not allowed to tax unimproved lands under the Nunavut Agreement, so we're just not going to. So all this case does is say they're missing another category that they can't tax. They're taxing a category they're not allowed to, so they need to not tax it just the same way they do with unimproved lands. Again, this is already happening. This is already something that assessors are being forced to do because PATA has never been amended. Like that's why this situation arises. Next slide. So as I said, there is a conflict here. And in fact, we say there's a conflict under both branches. There's clearly an operational conflict. I think that one's pretty hard to ignore. If QIA is right, that Inuit lands cannot be taxed unless they're improved, and again, the taxes are used for local government services and improvements, then it is impossible to comply with PATA at the same time, because PATA says those lands have to be taxed. You have no choice, you have to tax them. Nunavut Agreement says you have no choice, you can't tax them. So you can't comply with both. It's not possible. And that's enough for there to be a conflict. But we say there's actually also a conflict of purpose. As you heard my colleague speak to just a little while earlier, Article 22, and honestly, the provisions regarding Inuit lands in general were carefully negotiated to create a tailored tax regime specific to Inuit lands in recognition of the unique status of those lands. The regime was intended to ensure that the lands were going to be able to be used for their purpose, which was to promote Inuit self-government, self-sufficiency, economic opportunity, and that taxation would be limited to particular circumstances in order to facilitate that purpose. This was not a quick thing that happened. There was a very clear intention behind the creation of those lands. There's a very clear role that the DIO holds in holding the lands for the benefit of Inuit, administering the lands for the benefit of Inuit. So there was a lot of intention behind those lands. And in Article 22, the tax scheme is part of that intention. It fits in perfectly. And then you have PATA. Doesn't even mention Inuit lands. I mean, I think it's, again, incontrovertible that it doesn't facilitate the purpose of Inuit lands because it just doesn't mention them. It just doesn't contemplate them. We all agree about this. Like, there's no controversy that PATA has never been amended to address Inuit lands. So it's pretty obvious by extension that it's never been amended to ensure that the purpose facilitates those lands. And we say it actually conflicts with it. Treating Inuit lands the exact same as lands held by a private party totally fails to recognize the unique status of those lands, which, as Mr. Langlois said, isn't to say that the lands aren't taxable. They definitely are in certain situations. They are in a lot of situations. But when that situation doesn't arise, that careful scheme needs to be respected. PATA definitely does that. PATA just says with a broad brush, everything is taxable. Next slide. So what's the bottom line? I think it's probably evident from where I'm going with this based on everything we've just discussed. But it means that if you accept QIA's interpretation of Article 22, then there really is no choice but to find that sections 5 and 73 of PATA are inoperative to the extent that they conflict with the Nunavut Agreement. They can't be applied to tax Inuit lands if the Nunavut Agreement says, well, those lands can't be taxed. So the first step is, well, does the Nunavut Agreement let you tax those lands? If the answer is yes, great, PATA applies. If the answer is no, then you can't apply PATA to create tax on those lands. And this call out says exactly what we just discussed. That's already what's happening to a certain extent. And my colleague will get to this in terms of what does this mean for you, because this is sort of a lot of lofty constitutional law. But for you, the bottom line is quite a simple one in the sense that really it just amounts to cancellation of the assessments, right? If the lands can't be, you have the power to say, well, these lands shouldn't be taxed. And as we'll discuss, or as you'll discuss with my colleague, I should say, because of how paramountcy works in the Nunavut Agreement, we say that the lands can't be assessed because PATA doesn't apply here because it conflicts with the Nunavut Agreement. And that is what I have to say about paramountcy.
Chair, just a little update on timing here. We've got one more section to go through. This might be a decent time if you wanted to take an afternoon break. We're a bit ahead of schedule. I think we're going to finish prior to the 4:30 start time. So that might, I'll leave it in your hands as to whether you'd like to have time for questioning then, or if you'd rather think about it for the night, we can do questioning in the morning, but I am a little bit ahead of schedule.
Okay, well, let's see where we end up this afternoon to see if we can start questioning or not. And I'll take your recommendation. We'll take a quick 10-minute break. I have 1 o'clock Mountain Time right now, so we can come back at 10 after. And if you could please turn on your video when we come back so that we know everyone's here. Thank you.
Thank you.
Okay, well, welcome back, everybody. And I think we're ready to continue on, Jeff.
Your personal
Thank you,
guide,
Mr. Chair.
the world of
So we're moving on now to the last portion
Chair,
of our.
is Mr. Armstrong here with us?
Sorry, Kirk, I couldn't quite hear you.
Is Mr. Armstrong with us?
Oh. I can't see on my screen.
Yeah, I don't see him either. And I'm sorry to interrupt you, sir, but I just wanted to make sure the panel member was here when you were speaking.
Still in the breakout room.
Okay, so sorry, Jeff, I'm just gonna pause you then. We'll have to wait till Rick.
I will bring him back now.
Okay, thanks.
He should be in the room now.
Are you on? Are you on here, Rick? Oh, there he is. Okay, I see Rick is back, and apologize, Jeff. We can continue.
Great, thanks very much. So we're on the last section of our oral submissions now. What I intend to do next is go over the last 100 slides in 4 slides. And I hope I can sort of simplify and give you an overall roadmap for where our submissions have been. Then I'm going to talk about the order that we're requesting from the tribunal. And I'll end with one note about why you have the power to grant the order that we are seeking. So to recall back to the start of our submissions, we took you through Article 22 in some detail. A key portion of that, as my colleague Ms. Laskin has just detailed, is that Article 22 is the ultimate law of the land here in Nunavut. In terms of property taxation, to the extent that there is a conflict between Article 22 and PATA, and we've pointed out many conflicts that are just well known and that are dealt with each day by applying Article 22 over PATA. That is the state of the law. You can look to Article 22 as the source for the property tax regime in respect of Inuit-owned lands. Next, we took you to our interpretation of Article 22. This is where I think the bulk of your work and thinking is going to be required. You have competing interpretations. Our interpretation, which is that for Inuit lands to be taxable, they need to, in addition to being improved, they need to have local government services provided within the vicinity. Real property taxation cannot be imposed unless there are those local government services or improvements made in relation to the lands. If you agree with our interpretation, then the factual question that comes next is there local government services or improvements on or near the Mary River Inuit lands? There is no dispute about this. There are no services delivered locally. So if you're with us on the interpretation, based on the record that's before you, this job is done for you already. The parties have agreed. There are no local government services or improvements on or near these lands. The result of this, we say, is that the Mary River Inuit lands are not taxable under Article 22. If you only read PATA, PATA may suggest that those lands are taxable, but it's inconsistent with Article 22 pursuant to our interpretation. You determine that our interpretation is the correct interpretation, then we say that there's essentially one thing we are asking from you, We're asking first that you determine that these lands are not subject to assessment or taxation in the absence of local government services or improvements. If you're with us on that, then the order that we seek from you is relatively simple. It's simply to order the cancellation of the notices of assessment that are under appeal. If the notices of assessment are canceled, then there is no basis for the government of Nunavut to seek taxes from QIA in this circumstance. So on this point, Mr. Lambrecht Commission Counsel had requested, prior to written submissions being delivered, that we ensure that we provide some guidance as to the tribunal's authority to grant the order that we were seeking. I think that this is not in dispute as between the parties currently. I think it's appropriate that Mr. Lambrecht asked for submissions on jurisdiction, certainly. The materials that were delivered to you, including the notices of appeal and the notices of constitutional question, listed a number of potential remedies that the parties were seeking, some of which I'd characterize as like constitutional remedies, finding that legislation was invalid or inapplicable. To be clear, what we are seeking from you is not an exotic constitutional remedy. We are simply seeking an order that is well within the authority and the responsibility of the tribunal to order. The tribunal has the authority to decide questions of law that fall within the scope of complaints. One of the complaints that can be made to both the Board of Revision and the Assessment Appeal Tribunal is that this property shouldn't be assessed for taxation because it's not taxable. That's a question of law that's squarely within your jurisdiction. And you have the express authority to cancel assessments. And that, at the end of the day, is all we are asking you to do. So that's the conclusion of our slide deck. I think that I appreciate the patience and that everyone has shown today, and I look forward to questions about our submission. The final note that I'll give here is I think this is a very important issue, and it's obviously a very heavy burden for the tribunal to bear. The job that you're doing here will apply to the taxation regime that's to apply to Inuit-owned lands throughout the territory. And forever, potentially. Our submission overall is that the government of Nunavut has upset a very careful balance that was recorded within the Nunavut Agreement. And we look to the tribunal to look deeply at the text of the agreement and really give life to each of those words that the negotiators settled on. And so, subject to your questions, those are our oral submissions.
Okay, thank you very much, Jeff and Aria. I want to compliment you on the quality of your presentation today. And as per agreed upon in the order of business here, we are now permitted for our council to ask questions. So I'll turn it over to you, Kirk. Thank you.
Thank you, Mr. Chair. Council, my name is Kirk Lambrecht. I'm independent counsel to the Assessment Appeal Tribunal. And I would like to ask you a few questions, please. So I'd like to begin by saying that I would like to, in this questioning, to provide you with an opportunity to state your position on different perspectives so that so that the panel has an opportunity to understand that perspective. So we want to hear from you. And the first question that I have is, would you agree that tribunals like the Assessment Appeal Tribunal may only exercise power delegated to them, in this case, for this tribunal, by the legislature of Nunavut?
Yes, in a word, I do agree with that.
All right. would you agree that the parties cannot confer jurisdiction upon this tribunal by consent if such jurisdiction is not delegated to the tribunal by the legislature?
Yes, I do agree with that. But I wonder if you might elaborate on what the jurisdictional issue is that you see. Like I welcome some direct question on that.
Yes, I'm going to get there in very quickly, I think, but in a nutshell, to be immediately responsive to your question, I want to present to you a statutory interpretation of the Property Assessment and Taxation Act, slightly different than the one that you have advanced, so that we might hear your views on it. And in relation to that interpretation, the gist of it is this, that assessment for value, as defined in Part 1 of that Act, is different than the imposition of taxation under Part 3 of that Act. And that this tribunal has jurisdiction only in relation to appeals from assessment of value. The legislature has not delegated to this tribunal any authority to hear appeals from imposition of taxation under Part 3 of that Act. And therefore, we may not be able to give you the relief, all of the relief that you seek. Because when you look at your notices of appeal, you indicate that these appeals raise issues with respect to assessment and also taxation. And this is the Assessment Appeal Tribunal. This is not the Taxation Appeal Tribunal. The legislature has delegated to this tribunal no jurisdiction to hear appeals from taxation under Part 3 of the Act. And there's no right of appeal created to this tribunal from such decisions. So that's the thrust of it, Mr. Langlois. Does that assist you?
It does, yes. That's quite a direct question. I think I would like to take time to answer your question, consider your question. So it might be that I come back to you with a fuller answer tomorrow. The thrust of my answer is twofold, I suppose. One, these appeals have been outstanding for a number of years. No party has certainly raised that jurisdictional dispute to date. I would like to consider the specific part that you're raising there. And so what I'd suggest is that I come back to you in the morning with a specific answer, and I can take you through our thinking on that.
Of course. Now, if the tribunal has an obligation to hear the assessment appeals, in this case, what I understand the live assessment issues to be are the assessment issues related to the what's called the general area, the tote road, and a set of equipment that I'm going to call the crusher, for purposes of simplicity. And in considering those matters, would you agree that the tribunal can statutorily interpret the Property Assessment and Taxation Act and can consider and interpret under the principles of interpretation applicable to modern treaties, the Nunavut Land Claims Agreement?
Sorry, to recap your question, do I agree that they have the jurisdiction to interpret their enabling statute as well as the Nunavut Agreement?
When the issues arise in relation to an appeal of assessed value, yes.
Yes, my position is that they do have the authority to decide questions of law. And inherent in that is that they need to be able to certainly interpret their own enabling statute.
All right. So can you show me anywhere in Part 3 of the Property Assessment and Taxation Act where the legislature has delegated to this tribunal authority to hear appeals from taxation decisions as they are set out in Part 3?
Well, I appreciate your question. I think that's the question that you asked me initially.
Mhm.
And I'm happy to get you a fuller answer on that tomorrow.
Thank you. So if the tribunal were to interpret its jurisdiction as limited to resolution of issues related to assessment for value under Part 1 of the Property Assessment and Taxation Act, and not taxation under Part 3 of the Property Assessment and Taxation Act. Are there constitutional questions that arise in relation to assessment of value for the tote road here?
Not in our submissions, no.
And what about the general area? When we are dealing with assessment for value of the general area, are there any constitutional issues that may arise in your view in relation to the assessment of value of the general area?
Well, I might not be understanding what you're driving at when you're raising, is there constitutional issues? Could you clarify that?
Yes, does the Nunavut Land Claims Agreement affect the assessment for value of the tote road or the general area or the crusher or any of them individually?
Not in my view, no.
Okay. So would you agree that in its independent interpretation of the Property Assessment and Taxation Act and the Nunavut Land Claims Agreement that the tribunal might come to an interpretation of these documents, these instruments that are different from that advanced by QIA here this afternoon?
Sorry, do I agree that the tribunal may not accept my submission? May have
Yes.
a different interpretation?
Yes.
Of course.
Okay. Can I take you through, I'd like to take you through in the time that I have available, which I think is about an hour. Am I correct in that, Mr. Langlois? I'd like.
I'll leave that in the chair's hands, but I believe so.
Yeah, okay.
Yeah.
I've asked.
Sorry, Kirk, you were frozen for a bit there.
Okay. I have asked the secretary to be prepared to display some documents from your joint book of authorities, and I'd really like to begin, please, by asking the secretary to display Article 22 of the Land Claims Agreement. And the article that I want to look at in particular is 22.2.1. Mr. Secretary, are you able to enlarge that at all? If not, I'm perfectly okay with proceeding.
I can read it fine.
All right. Now, there's two phrases that I would like to discuss with you here. Mr. Secretary, are you able to highlight this document from your end?
I do believe so.
Okay. Can you highlight the phrase, no federal, territorial, provincial, or municipal charge, levy, tax of any kind whatsoever shall be assessable or payable? Yeah, that's not going to work, Mr. Secretary, so that's fine. You can
Okay.
You can discontinue that. It'll become a distraction. All right. Mr. Council, do you see that phrase there that I've read out? The phrase, no federal, territorial, provincial, or municipal charge, levy, or tax of any kind whatsoever shall be assessable or payable.
Yes.
Is that the prohibition of taxation?
That is the broad prohibition on applying taxation aside from what is permitted under Article 22. That's our
Right.
position.
All right. So then let me just back up a moment. In the phrase immediately preceding that, it says, subject to this article and the agreement. Would you interpret the words subject to this article and the agreement to be exceptions to the prohibition on taxation in some way?
Well, it is, and that was my main submission.
All
That
right.
this is a broad prohibition on taxation of any sort. Aside from that, that's permitted within the agreement broadly, but the various exemptions are within this article.
Right. So when I look at this clause, it says subject to this article and the agreement. In listening to your submissions, I understood that the article had some exemptions. So for example, no uh, um, exemptions relating to improvements for traditional purposes, like outpost camps, for example, and
Well,
the real property taxation in addition. And what I
I think
wanted
those
to,
are two different things, though.
Mhm.
This article here in our submission is that there's a broad prohibition on tax unless otherwise allowed under this article. So there might be different use of the word exemptions or exceptions that we're making use of. The next two sections set out real property taxation is permissible in certain circumstances. The section you've noted in relation to improvements, particular classes of improvements, there are certain improvements that are not assessable or taxable.
all right. So the phrase subject to the agreement, in your view, are there any other provisions in the agreement that might bear upon the exception to taxation here in Article 22?
In relation to real property taxation or property taxes accessible as against Inuit-owned lands? No, not that I'm aware of.
All right. Then I'd like to take you to the word on in the third line, the first word of the first line here. And I'd like to read the phrase after that, which is this one: the value or assessed value of Inuit-owned lands. Do you see that phrase?
I do.
Okay. So if I take the first phrase, federal, territorial, provincial, or municipal charge, levy, or tax of any kind whatsoever shall be assessable or payable. I can shorten that in, as I understand it, to, in your words, to no real property taxation. Would that be a fair statement? No taxation other than real property taxation.
I think so, though I'm not sure I know where you're going with your question. So I think that's probably, that would be my submission, that any sort of tax is not assessable or payable on the value or assessed value of IOL.
Right.
Other than real property taxation.
What I want to put to you then is the observation first, that the word assess is used in two senses here. The first one is assessable or payable in relation to tax. The second is assess in the sense of assessed value of Inuit-owned lands. So the proposition that I would put to you by way of interpretation is that it may be that this clause allows for the assessment for value of Inuit-owned lands, pardon me, because assessment for value is different than taxation within the scheme created under the Property Assessment and Taxation Act. So when I look at 22.2.1, I see it recognizes that no tax will be payable on the assessed value of Inuit-owned lands. And I wonder if we could ask for reviews on whether this anticipates, when we pay close attention to the text, that there may be assessment for value of Inuit-owned lands independent entirely of the taxation applied to that assessment for value.
Well, I can certainly consider your question. I think it's quite related to the first question that you asked me, which is what's the jurisdiction of this panel to hear appeals regarding the taxation rather than the accessibility or assessment of property. So I appreciate you raising that so directly, and I think what I'll do is consider that tonight after the break and bring that answer back to you.
In that case, sir, it might be helpful if I walked through the provisions of the Property Assessment and Taxation Act so that we might have a common platform for your overnight consideration.
Yeah, I welcome that.
So, Mr. Secretary, can you take this down, please? And can you pull up the Real Property Assessment, or the Property Assessment and Taxation Act? I believe it is tab 51 from the Joint Book of Authorities of the QIA and BIMC. All right. I'd like to begin, Council, just by walking through the table of contents of the Act to make sure that I identify the different parts of it. And then I'm going to go into some of the sections that are within those parts. So first, after some definitions, there is Part 1 assessment. Mr. Secretary, could you just go back, please, to the page you were at? Thank you. And I'm going to, if we look at Part 1, it has different subheadings: liability to assessment, the manner of assessment, the property classes, and you can go on, Mr. Secretary, to the next page of this table of contents. After the assessed value is identified, it is placed in an assessment roll, and ultimately a notice of assessment is sent to the assessed owner. I'm going to call all of that process under Part 1, assessment for value. Now, in particular, while we're here, I'm going to ask you to turn up sections 27 and 28. Within Part 1. So, Mr. Secretary, you'll have to scroll through here to where we are to get to sections 27 and 28 within Part 1 of the Property Assessment and Taxation Act. All right. And the end result of assessment for value is that a notice of assessment is mailed to the assessed owner. That was originally BIMC. It is now QIA. And these are the notices of assessment, which were the subject of complaints to the Board of Revision. So the complaint to the Board of Revision related to the notice of assessment. And the appeal to this board relates to the notice of assessment for value. Okay, so that's one way to see the scheme of part one, that it creates assessment for value. We can then go to part two. And part two creates the Board of Revision. Part three, or part two, and this Assessment Appeal Tribunal. And it provides for appeals. The legislature has created a right of appeal by way of complaint, first to the Board of Revision and then by way of notice appeal to this tribunal, from notices of assessment for value, specifically. Mr. Secretary, are you able to go back to the table of contents here? And while you're scrolling there, Mr. Secretary, I'd like you to take us to where the table of contents refers to part two of this act. All right. So part two is headed Assessment Complaints and Appeals. It has a provision for the boards of revision and the powers and duties of the Board of Revision. And then you can go on, Mr. Secretary. And it has then a provision for the Assessment Appeal Tribunal, common provisions for both of those. And can you go on, Mr. Secretary? And then assessment appeals, which is where we are here. So the proposition that I would ask for your views on is simply this, that the scheme of the legislation anticipates for assessment for value under part one, an appeal mechanism, first to the Board of Revision by way of complaint, and then on appeal to this tribunal from the Board of Revision, relating to the assessments for value specifically. And that taxation is addressed in part three of the Act. So here we have part three, and I want to, in this section, identify a number of provisions specifically. So, Mr. Secretary, can you please take us to section 75, sub 1? All right. Council, I'm going to walk through a few sections here. The ones that I think outline the key steps within part three of the Property Assessment and Taxation Act. through which property is taxed. The first of these is 75-1. The second of these is 78-2. Mr. Secretary, just stay here for the moment. The third of these is 88, and the last of these is 89, 1B, and 90. So I'm going to walk through each of these in turn to give you an opportunity to see what I'm referring to, so that you might have the opportunity to reflect on that, like specifically. The first section I want to refer to is 75-1. Now, this deals with mill rates. And it provides that the Minister of Finance shall establish a general mill rate for each property class in the general tax area, and an educational mill rate for all assessed property in the general taxation area. Mr. Secretary, you don't need to do that. Thank you. Thank you, sir. But unless I ask you, it won't be necessary to do so. For the purposes of raising a property tax for territorial purposes. So the very first of the steps for the assessment or levying of tax under Part 3 is the establishment of a mill rate that has two parts, a general mill rate and an educational mill rate. If we then go to Section 78, for assessed property in the general taxation area under Section 78, the general mill rate and the educational mill rate are added to get what is described in the legislation as the total mill rate. Mr. Secretary, you can go to the next page, I think the next 78 page, because the description of these calculations carries on there. The total mill rate is multiplied by the assessed value of the property under Part 1 as described on the assessment roll. And the product of that is what's called the property tax payable, or the total property tax payable. So this is the property tax calculation. If we then go down to Section 88, the tax payable is entered onto the tax roll as distinct from the assessment roll. And there is one tax roll for the general taxation area. And you'll see in 88.2 what it must contain. Mr. Secretary, can you then go to 89.1b, Section 89.1b of Part 3 of the Property Assessment and Taxation Act? Under 89.1b, where property taxes have been calculated under this part, which is Part 3, the collecting authority shall cause to be prepared and mailed notices of tax payable to the assessed owners named on the tax roll. Now, at the outset of your submissions, you referred to the tax bill. In plain language, the notice of tax payable is the tax bill. It is not the notice of assessed value. And I would really like you to consider this interpretation of the legislation overnight, so that we might have the benefit of your views in relation to that. And let me be clear about this, so that if the tribunal has appellate legislation only in relation to assessed value, as determined under Part 1, and if the legislature has not conferred upon this tribunal, the Assessment Appeal Tribunal, jurisdiction to hear appeals from tax as calculated under Part 3, then this tribunal can hear the appeals as they relate to the assessed value of the tote road and the general area and the suite of equipment I will call the crusher. But it may not have the jurisdiction to deal with the taxation issues that you wish to raise. And I would really like to hear your views on that, please.
Certainly. So I think I understand the outline of the submission or the question that you've asked me there. I think what I'll do overnight is consider your question and bring that back to you. Having this issue not having been raised by any party to date, I want to make sure that I take time to think about it rather than on my feet currently.
Thank you very much. Can I ask you a few questions then about the opposite point of view, which is, let us assume then that the tribunal comes to the conclusion in its interpretation of the legislation that it can't answer the constitutional question that you have framed. Are you with me on that?
Yes.
Okay. In this sense, I want to refer you to a paragraph of your factum. So, Mr. Secretary, you may want to, from the tribunal record, in the tribunal record, there is a written submissions of QIA. And if you wouldn't mind pulling those up. Specifically, it's paragraph 136.
Paragraph 136.
Yes, I believe so. While this is occurring, Mr. Langlois, can I ask you to describe what you understand to be the area that is referred to in some of the materials as the hinterland?
Hinterland is the area outside of the municipal boundaries of a Iqaluit.
All right, so just to make sure that I'm clear, is the hinterland everything in Nunavut outside of the boundaries of Iqaluit, including the municipal areas outside of Iqaluit, other than Iqaluit?
I think that's right, but I'd have to double check.
All right. Now, the point that I want to try to understand here is that only Iqaluit is a municipal taxing authority. The other, my understanding of your submission is that the other towns, villages throughout Nunavut do not have taxing authority. Is that correct?
That's correct.
All right. So, Mr. Secretary, are you able to find paragraph 136? Yep. I'm just going to take a moment for this to be
Got it now.
visible. Thank you, sir. Okay, so here you make the point that we've just covered while the secretary was getting this document ready for display, which is that only Iqaluit is a municipal taxing authority with the power to levy tax. Throughout the whole of Nunavut, including all other municipalities, it is the government of Nunavut that has taxing authority. And you say that in future, it is possible that the other municipalities in Nunavut would become municipal taxing authorities, in which case the government of Nunavut would be out of the business of providing local government services. Are you with me, sir?
Yes, those are certainly the words provided in our written submission. I can expand on them.
Well, the question I have for you is, what should the tribunal make of this? Is this a recognition by QAA that the government of Nunavut is in the business of providing local government services outside of Iqaluit?
Well, let me make sure I understand the import of your question. Right now, there are local government services that are offered outside of Iqaluit. There are schools, there are roads, there are a variety of local government services. So is it an admission? I think that's the record that's in front of the tribunal right now. In other communities, there are local government services that are offered.
Are they offered by the government of Nunavut?
They are, yes.
All right. So the government of Nunavut is in the business of providing local government services throughout Nunavut outside of Iqaluit.
The government of Nunavut offers local government services in particular areas of Nunavut outside of Iqaluit. I think the record that we have here is that there are areas of Nunavut, vast areas, where there are no local government services that are offered. But I don't contest your point, and I think it's a point I made a number of times during our submissions, that there are local government services offered elsewhere, and that the government of Nunavut, they indicate that they fund some of those. Frankly, that's not in the record in the main. But are there local government services offered outside of Iqaluit? And the answer is yes.
I would like to ask some documents about what the record contains in relation to the taxation process under Part 3 of the Property Assessment and Taxation Act, and in particular, a couple of specific questions. With respect to the order of the Minister of Finance establishing a general mill rate and an educational mill rate under Section 75 Sub 1 for the purposes of raising a property tax for territorial purposes. Are any of these orders in the tribunal record?
I don't know the answer to that offhand.
And
let me follow up on that specific question.
Thank you. Is any part of the general taxation area tax roll in the record in this case? that is the general taxation area tax roll defined in section 88 of part 3 of the Property Assessment Taxation Act.
Is any part of the tax roll. So now there's been individual tax bills that have been delivered. So I don't know if the taxation roll is, but I'll endeavor to find that in the record for you.
All right. And then you just mentioned individual tax bills, and I'm wondering if the tribunal record contains any of the notices of tax payable sent to QIA pursuant to section 89 1B of part 3 of the Property Assessment and Taxation Act.
I'll confirm that.
Thank you. I have a question for you about the lease. And I read, you can take this down now, Mr. Secretary. Thank you, sir. The lease, but has been referred to in a number of different places. And I want to make sure I understand there may be 2 different leases. The first one is the lease of the mineral interests that are being mined, the iron ore. The second lease, I think, is a lease of the surface to allow Baffinland to enter upon the surface to access the iron ore. Now, the second lease, that is the lease between QIA and BIMC, and we have that in the record. Do we have the first lease, the lease of the minerals, in the record?
No, I don't believe that's in the record. And that would be a lease, as I understand it, and perhaps BIMC could speak to this tomorrow in their questioning. But as I understand it, that was a lease entered into with a predecessor of BIMC and the Crown.
All right.
I don't believe that's in the record.
All right. Now, I understood the lease to be introduced to this tribunal in the affidavit evidence referred to in the affidavit evidence of QIA. Am I misunderstanding that? Or is it in the evidence of another party?
I think it's, perhaps you could let me know what you mean by introduce. I believe that in our affidavit evidence, it is discussed. It's also discussed in our agreed statement of facts.
Mm-hmm.
I'm having a hard time remembering exactly where the lease is appended to right now. If it's one of BIMC's affidavits or one of our own.
Is the lease relevant to the definition of the term demise?
You might have to expand on your question for me a little bit. So there is a demise within the lease of a particular area.
Mm-hmm. Certainly, one moment. Just let me get my...
If I could assist, the lease, if you're looking for it, is in 2 places, I think. Exhibit I to the affidavit of Jerry Towns, which would be at GN 132. And I think it's also in BIMC's materials, but I can check that as well.
All right.
No, that's right. It's in Exhibit H of the Anderson affidavit, which is
yes. So it's in 2 places.
Mr. Secretary, could you pull up again Article 22 of the Nunavut Land Claims Agreement? specifically, Mr. Secretary, I'd like in this occasion to refer to 22.2.3. Council, I'd like to refer to the second sentence of this, and I'm just going to read it out. Notwithstanding, where an improvement has been constructed and an area of land for that improvement has not been demised, the assessor may assign an area no greater than 4 times the total ground area of the improvements. And Council, I want to refer you to the phrase, an area of land for that improvement has not been demised. What is QIA's position? Has an area of land for the Mary River improvements been demised? Or has an area of land for the Mary River improvements not been demised?
I must confess, the focus of our argument has been around the taxability, the liability for assessment and taxation of this property. We have deferred to our tenant, QIA's tenant, BIMC, to deal with matters relating to the actual assessments and the assessed value. You're asking QIA's position as to whether any land has been demised through the lease. I think before I answer that, I ought to consider that, and it might be that question's best directed to BIMC, but I'm happy to consider that and bring an answer to you tomorrow.
Thank you. I've read your submissions that the lease is not relevant. And I've heard you.
Yeah.
And I've heard that repeated a bit today, but I'm a little bit uncertain about what to make of it because if the term demised, as referenced in this section of the Nunavut Land Claims Agreement, means leased or may include a lease, then clearly that is relevant to the assessment of the general, or may be relevant to the assessment of the general area. And I cannot understand your submission that the document is not relevant.
Well, I'd like to clarify the submission that we have made as to the lease not being relevant is specifically, it is not relevant to an interpretation of the definition of real property tax under Article 22.
All right, that's helpful.
Yes, the government of Nunavut has included reference to the lease in its argument, essentially arguing, well, look, these parties thought that the property was liable to assessment and taxation because, and the evidence of that is they concluded a triple net lease that provided that BIMC was to pay the tax. So specifically our submission is that term of the lease, I think factually it's not helpful, but it's not relevant in our submission to undertaking an interpretation of Article 22. This lease was entered into not by the parties who negotiated Article 22, but by others.
Mr. Secretary, can you scroll up to the definition of real property taxation at the beginning of this Article 22, please? Council, while the Secretary is pulling that up, I want to try to get an understanding of Well, I want to compare, I want to go back to the assumption that the tribunal may interpret its jurisdiction in such a way as to enable it to respond to your constitutional question about the taxation of Inuit-owned lands. And I want to do two things here. I want to focus firstly on the phrase for local government services or improvements, including schools or waters. And here I think schools is something that I want to ask you about. Now, Mr. Secretary, are you able to pull up again Section 78 of the Property Assessment and Taxation Act? While this is occurring, Council, 78 was the section that dealt with the fixing of mill rates, or 75. I'm sorry, Mr. Secretary, I should refer to 75. It's my mistake. And I want to refer you, please, to 75(1)(b). Which refers to the educational mill rate. Now, if the government of Nunavut includes an educational mill rate in the calculation of property tax, what is your view about the relationship of that to the provision of local services, local government services in the hinterland and its communities, including schools?
Sorry, what is the relationship between the fact that they are raising an education mill rate and their provision of services? You know, by the
Yes, I guess I could put it this way. It would seem if an educational mill rate is included within the calculation for tax payable, that this is in relation to local school services in some way. And I'd like to ask if you've given some thought to that, or what your position may be about the relationship between an educational mill rate, which is inherent in the tax under Part 3, and the delivery of and the real property tax definition in Article 22 of the Land Claims Agreement that makes specific reference to schools.
Yes, so this is something that we have considered. So it's clear that in the general taxation area, they are applying two mill rates, a general mill rate and an education mill rate. They are raising funds on both of those mill rates. As you've described, there is a mill rate times the assessed value, and that arrives at the taxation imposed on lands. So I don't deny that there are funds being raised by the government of Nunavut. And as I answered earlier, there are local government services that are delivered elsewhere in Nunavut. The interpretation that we have asked this tribunal to agree with is that, notwithstanding that there are local government services that are provided in areas far distant from certain Inuit-owned land, that taxation cannot be, or Inuit-owned land is not liable to assessment or taxation unless those local government services such as schools are provided proximate to those Inuit-owned lands.
All right. So can I ask you some questions, please, about the proximate aspect of what you're asking about? That the local government services need to be delivered in some way in an area proximate to the lands that are taxed.
Yes.
Okay, thank you. If the Mary River mine were adjacent and contiguous to Pond River, could the government of Nunavut tax it under the existing provisions of the Property Assessment and Taxation Act?
Provided that there are local government services or improvements made in that community, the answer is yes.
All right. So let's take the Mary River mine and move it away from Pond Inlet back to where it actually is. If the government of Nunavut were to deliver any local service, would that make the mine taxable under the current provisions of the Property Assessment and Taxation Act?
It may, yes. And I'm, your words local service there, I'm assuming that you are defining that in the same way that we do.
Well, like, what would the government of Nunavut have to provide in order for these lands to be taxable that they're not providing now?
I don't think that's a question that you need to answer here. And you know, I can speculate on that. And I've said during my main submissions here that we would not be here if there was any thread to tie to this area in a very real sense. This area, and this is why I think the request that QIA is making through this appeal is fairly modest. This situation is quite unique. There are no services here whatsoever, despite the fact that there are considerable improvements on the lands. So could I speculate as to what kind of service that would have to be? Perhaps, but I don't think it's needed. I don't think that the tribunal needs to grapple with that question in making a determination that that on these lands, there are no local government services or improvements. I think that's a matter of no dispute on the record that's before this tribunal. I would suggest that there might be cases in the future that might deal with, well, is that a local service? This item of government spending? That could be the case. But I suggest that's not a question that this tribunal has to grapple with. I'm not trying to put off the question. I think it is important to try and understand what would be the impacts of this. But for these, the direct impact is for these lands, for these particular years, the direct impact of our interpretation is that there should be no assessment or taxation of these lands.
You mean assessment for value or assessment for purposes of charging a tax? Which sense of the word assessment are you using?
Right, and so an assessment, as I'm using it there, is what is the assessed value of the property? And I'd like to spend some time getting back to you on that question again tomorrow. And I think we can do that in a fuller way, but from my perspective, there's a broad exemption for from both assessments and taxation. I will answer your question more directly tomorrow about what's the tribunal's jurisdiction. But there is no purpose for assessment if there is no taxation that can attach. Where's the right tribunal to sort that question out, I think is the question you're asking, and I'm happy to answer.
think it's the affidavit of Stephen Bathory, Exhibit Y. Mr. Secretary, would you mind pulling up the updated affidavit of Mr. Bathory and go to Exhibit Y? Mr. Counsel, our record includes two of these. I think one of them, they're identical for all intents and purposes, as I understand it. Just one did not have the exhibits commissioned, and
Oh, yes.
the updated one corrected that oversight. And what I want to refer to here is a document which is introduced by the witness in his affidavit by saying that the government of Nunavut recognizes that the Mary River mine is in the general taxation area. But I want to look at the document itself because it's quite different, and I would like to ask you what it is and what use the tribunal should make of it.
I have the exhibit open. Were you hoping to bring it up on screen?
Yes, I was.
Sorry, Kirk, what folder is it in? Or what
It's in
document?
QIA. It's in the QIA folder, Mr. Secretary, and it will be within that folder. There are several affidavits. I think we're talking about the updated affidavit of Stephen Bathory, Exhibit Y.
While we're pulling that up, I've got one clarification to make on a question I only half answered earlier. So you asked, what is the hinterland? Is it the same as the GTA, the general taxation area?
No, I didn't. I asked, is the hinterland everything outside of Iqaluit?
Oh, sorry. And the answer to that is no.
Right.
The hinterland is everything outside of those, outside of communities.
Right. Okay, that's helpful. So if we step outside of Iqaluit, while this is occurring, just to make sure that I'm clear, it is the government of Nunavut that imposes tax outside of Iqaluit, whether that is in a community outside of Iqaluit or in the hinterland outside of Iqaluit. Is that correct understanding?
Yes, that's the general taxation area. The general taxation area encompasses those communities.
All right, thank you, sir. Now, when I went to look at Exhibit Y, it appeared to be a series of questions and answers. And if I understand it, it appears that this was a series of questions asked by QIA of the GN relating to the assessment process at some early point in time. But I wonder if I can ask you to actually describe what this is. What is this document and what use should we make of it? Because it provides a lot more information than simply that the mine is in the general taxation area.
Right. So my recollection, we've had a significant delay in this hearing, so it's been a while since I've read this document, but my understanding is that what you described is exactly what it is. There were questions that QIA put to the government of Nunavut regarding their assessment process, and the government of Nunavut answered those questions.
Could you go then, Mr. Secretary, to the next page? Page 2 of 16. And could you go to the next page, please? And the next page. And the next one, please. Number 10. Mr. Secretary, could you take a moment to pull that up? And Council, could you take a moment to read that, appreciating that it may have been some time since you did so? Council, let me know when you've had a chance to read that.
Sure, one moment. Okay, I've read the statement.
I think what this means is that the Mary River Mine is the only mine on Inuit-owned lands in Nunavut, and that there are no other comparable mining situations to this one. Is that how you would interpret that statement?
So this is me interpreting the Governor of Nunavut statement. That appears to be what it says. I know outside of the record that...
I'm not asking you to go outside of the record.
Fair enough.
I think that...
Could I offer one item here? You asked earlier, what's the use that the tribunal should make of this document? And this comment likely applies to a number of other documents that are within, particularly Stephen Bathory's affidavit. And I can offer this as I offered at the start of my oral submissions. There were initially 3 issues set forth in the notices of complaint. The first is the issue I've spent today on, which is, are the lands liable to assessment and taxation? The second issue was, is that assessment amount, is that the correct amount? Is that a reasonable assessment? And the third issue, which QIA put forward and Baffinland took another perspective on, the issue that we put forward was QIA is not the proper assessed owner under PATA. We're not making that argument any longer and have withdrawn that in our written argument. A number of pieces of evidence like this, the use to which you should put these documents was primarily towards that third argument. I don't intimately know the context as to why this letter was sent and answered, but for us, this was a useful, this could have been a useful item that would go towards, is QIA the proper assessed owner or otherwise? But if you have a more specific question as to whether or not this is helpful or not.
I have one final question, and it's in relation to the notices of constitutional question. Specifically, it's in relation really to BIMC's notice of constitutional question, but I think you would be familiar with that. Mr. Secretary, perhaps you could pull up from the NCQ file in the tribunal record the BIMC notice of constitutional question and go to the very last page of it. Just above the signature on the document.
Sorry, that's from the tribunal record?
It's in the tribunal record in a file called NCQ. And there will be a notice of constitutional question filed by BIMC. While the Secretary is looking for that, Mr. Langlois, when I was reviewing the notices of constitutional question, I saw that BIMC had raised an issue of discrimination under the Canadian Charter of Rights and Freedoms. And I did not see that issue referenced in any of the written submissions. And I would like to ask if QIA is advancing any argument relating to discrimination under the Canadian Charter of Rights and Freedoms.
Yeah, specifically the Section 15 argument. The answer is no, we are not.
Thank you, sir. Then I don't need to have that come up. Mr. Chair, we're at 4:30, and I think this would be an appropriate time to break for the day.
Okay. Again, I want to thank all the parties for their participation today and the challenges that comes with having to do this by Zoom. So tomorrow we will reconvene and we will commence with questions and answers. Before we get to the panel themselves asking questions, I think it would be appropriate, Jeff, if we give you the opportunity to respond to the ones that were left for today.
Certainly, I've got some homework, so thank you.
Okay, and yeah, and then we'll just proceed as per the directions that I gave at the beginning of the meeting. So I want to thank you all very much. I'd ask the panel to stick around. We'll go to a breakout room, and we'll see you all tomorrow. Have a good evening.
Thank you.
Thank you, my friends.
Thank you.